Let me get this straight. You blew up a building.
2 CIs and the CEO of 22andU.
2 competing federal agencies with the same mission.
I don't understand why those Fed a-holes are so darn mean.
To protect the public from the scourge of dangerous misinformation.
You know those bum idiots. This is all them. We had a solid case.
The word entrapment, not even in their vocabulary.
The explosives we provided were fake.
Sworn to a duty to always tell the truth.
We have no indication at this time that this was a deliberate act.
We're all being transferred.
To where?
The only place currently with openings. Alaska.
Good morning.
Welcome to the office, huh?
And we got the retro feel. You know, the funny about federal buildings, they're all different, but they're still somehow all the same.
Oh, good morning, Agent Walker. At the coffee station. We actually drew straws before he got here, and I won, so we get to work together.
Let's get started. Let's see if we can't stir something up.
Let's give it a minute. I like to warm up the truth muscles a little coffee beforehand.
Well, what do you want to do first?
What do we have for a surveillance van?
Oh, wow. I got a Ford Explorer. We don't have a surveillance van.
Do you put many cases here?
Cases?
Yeah, cases. We're the tip of the spear when it comes to protecting American democracy.
You really believe this? You really believe that people posting crap online is going to cause our country to crumble?
I think the work that we do is important.
We don't have a surveillance van.
Me and some people got one. We've never needed one.
We need a surveillance van. We need a big case or a CI who can lead us to a big case.
What do you need the van for?
Surveillance.
CIs, or confidential informants, are the lifeblood of any good law enforcement agency. Public posts on social media are one of the best ways to find CIs. Agents would never use coercion or take things out of context to try and persuade someone to become a confidential informant.
The new Taylor Swift single is absolute fire. I'm just seeing a lot of incendiary and violent language here.
Agents always need to be on their toes and ready to make snap decisions.
Is there anything I can do for you guys? Actually, David, there is something you can do for us.
Chicken nuggies.
Chicken nuggies.
What?
Cheeseburger.
Cheeseburger. McDonald's cheeseburger.
Burger King.
Burger King cheeseburger.
Flame broiled.
And chicken nuggets.
Oh, baby, know you're gonna like it. I wanna be your beaver pilot. Said, honey, know you're gonna like it. I wanna be.
Awesome, right?
Is this a loner?
This thing's totally legit.
What is this? It's got windows!
Oh, the good old surveillance van with windows. Never gets old. It never gets old. I love it so much. I can't wait. July 4th. July 4th is the official release date for our show. Mistakes were made. The trailer that you just saw coming in there. That is our show. We are making fun of the government, which needs to be made fun of no matter what or who or why is in there, especially when it comes to all the misinformation BS and people trying to disrupt your First Amendment rights. It's just not right. Just can't do it. So, hello. Welcome. Ooh. I just turned myself on there. Wait, what? I turned on the the show there on my phone. Yeah. All right. Well, welcome to the show. We have my sidekick Finny down there, Mr. Dog that is asleep on the bed. kind of asleep. We'll see. We'll see if we get any dog dreams tonight. And on the stand today, we had the beginning of the cross-examination of Judd Welcher from Aperture, the Commonwealth of Massachusetts main expert, crash reconstructionist, whatever the hell that was. So yesterday was a mess. Yesterday was just a mess. And so you knew this guy was not going to want to cooperate today. He just was not going to want to cooperate. It ended the day with him saying, that is what happened. That, do you have an opinion as to whether the vehicle of Miss Reed collided with John O'Keefe? And at the end of the day, he said, that is what happened. You cannot, as an expert, just come out and say that's what I mean. Yeah. So I did not catch the ruling. I caught the very beginning, I think, of the testimony this morning, but I did not catch her ruling on that. So we're going to just jump right in. Let's jump right in. I got, what's good is Andrea did not go over 10 hours today. So we've got a transcript, and a transcript on YouTube is very, very good to have. So let me bring that up, and let's see what the ruling was about what he can testify to. Which I'm sure it's going to suck. It's not going to be everything the defense wants. It'll probably be a lot of what the prosecution wants, because that's just how Bev's rulings go.
These things line up. It's a weird looking 3-point turn to me.
All right, so Dr. Welcher can testify that the data he downloaded and analyzed and the damage to the Lexus is consistent with Ms. Reed's vehicle being in a collision on January 29th at 12:32 a.m. because he's a qualified expert and his opinion is based on reliable methodology appropriately applied. Reliable. In addition, Dr. Welcher can testify that Mr. O'Keefe's injuries are consistent with his having been struck by a Lexus that is physically identical to Ms. Reed's Lexus, because this opinion is based upon, among other things.
Right. Yes. Yeah, and we'll go through the cross today. I was I don't know. I just Welcher's a Welchy, a weaselly, has to argue every single thing person. But I think Alessi was a little frustrated with him. I do, because he made some, you know, I don't know. Just, and then the objections were tough on him. So it was, you know, he got some good points in, but Welcher really fought him on every single thing. So, okay,
his experimental work that came into evidence without objection as to scientific methodology and application.
No, it's not.
However, he may not testify that Ms. Reed's Lexus collided with Mr. O'Keefe because that conclusion is not based on the application of reliable scientific methodology. The problem here is not that the opinion concerns the ultimate issue, because
way too much. Yeah, he just kept going on and on and on and on and on.
Is that Dr. Welcher, the expert, is drawing an inference based upon more than scientific method. His opinions set the stage for argument and a permissible inference to be drawn by jurors through the application of their sound judgment to the opinions that they find credible. But the jurors are as well positioned to draw or reject the inference as is the expert. That is, the inference is not compelled by the application of any scientific method. So that's the ruling. All right.
She didn't really touch on, I mean, she basically just said what he can say, what he can't say. She didn't really touch on I think the arguments, especially that Alessi made, I don't know. That's just it's still all of this is up for review. All right, so now we get Welcher back with us, and we get the ending of the case. So I just got this in the mail today. Let's take a look at this real quick. I want to show you this before we go on. Let me get into my. Give me a moment because it's up. Hang on. I am gonna hide this for a moment. Thank you very much. Bear with me. I got a cool comic book in the mail today. And it is The Adventures of Auntie Bev, The Biased Antics of Auntie Bev. And because I have my green screen on, it's not really showing up that great. But let me log in here. It's going to take me a second because I got to do the OTP. OTP! You know me. Oh, shit. Beep. Sorry. Beep. 26. No, I don't need to say the passkey. All right. So, all right, my orders. Here we go. The Biased Antics of Auntie Bev in the Karen Reed case. This is a comic by Lynn Marie Emmerich. And it's, I saw her on X. And I saw this and I'm like, what is that? And so I thought that was, I wanted to support people all around that are doing things for this. So let's see if she comes up. Yep, here we go. So this is her X profile right here. Reasonable doubt in the Karen Reed case. So she's a very good artist. Yeah, I keep thinking about that too. She makes a good point here. I keep thinking about when Dr. Wolf from ARCA gets on the stand, one of the first questions, I'm sure it's going to be Alessi, but it might be Jackson that leads that. It could be Jackson. The first question he is going to ask, Dr. Wolf, when doing a crash reconstruction, have you ever dressed up like the person who got hit? If you're doing a pedestrian reconstruction, have you ever put on the exact clothes of the person being hit? Because that shit was weird. That was weird. So yeah, so she's got some cool stuff. I figured I would support her and get one of the comic books. And so I will check it out tonight and report back. But yeah, I thought it was pretty cool. Okay. All right. So now we get let me share. Make sure I'm sharing. I'm going to make sure I'm sharing. So
consistent, but not that he actually caused it.
My finger. So I am counting my fingers. The ring.
That was odd, man. That was so weird.
Height,
so weird.
The type of shoes he's wearing because I need the same type of shoes. My exemplar inspection where I matched up the heights.
Can't forget the coastline.
The locations of the lacerations, and then the tech stream data as well.
Oh, that seems.
That information that you consider.
In addition to the text stream data you considered.
That's 1.5 speed. These guys are talking so slow.
Considering both those areas of information, do you have an opinion to a reasonable degree of engineering certainty in whether the damage to the defendant's Lexus is consistent with a collision with Mr. John O'Keefe on January 29th, 2022 at around 12:32 a.m.?
So there's been two potential theories that I've seen on that issue. One is a glass was thrown at the rear of the vehicle and shattered it. The second one was an impact to the arm. If the impact is basically more than approximately 8 miles an hour, it will likely break the taillight lens.
Do you have an opinion whether, based on the data and based on the physical damage and your testing, whether that is consistent with a collision or a impact with Mr. John O'Keefe?
It is consistent with a collision as long as it's greater than approximately 8 miles an hour.
Do you have an opinion whether it's consistent with an impact or collision with Mr. John O'Keefe on January 29, 2022 at around 12:32 a.m.?
With that caveat, yes.
In your testing, did you consider, or do you have an opinion to a reasonable degree of engineering certainty, whether John O'Keefe's injuries on his arm, and inevitably in the back of his head, are consistent with being struck by a Lexus identical to the defendant's Lexus on January 29, 2022?
Yes.
What's your opinion?
That it is. It is consistent with being struck by a Lexus and ultimately contacting a hard surface such as frozen ground.
Such as frozen ground.
The hard frozen ground. You got to make sure that you get the hard frozen ground thrown in there, because why not?
To January 29, 2022 around 12:30 a.m.
Objection, Your Honor.
I'm going to allow that.
Yes, it does.
Frozen ground. Where was the methodology for that one, Bev?
You've written some papers on side swipe collisions.
All right, so then we get into some weird stuff today.
Where there's an absence of broken bones in the
Go and they show some more slides, and one of these slides is like a section. So they showed this slide with this dude who looks beat to hell, who got thrown 30 some feet, right? Says right there 38 feet that he got tossed.
Where there was DNA transfers.
He's got tissue and blood and stuff that transferred to the car. The car is beat the hell up. He got thrown 38 feet. And then they show the guy, which is weird.
At the scene.
And he looks beat the hell up. And he's got fractures. He's got fractures of the right posterior ribs. And I thought he's got multiple abrasions of the right knee, left anterior leg, lower back. And so I don't know that this actually helped their case. Weird.
Subject to redactions, Dr. Welch's PowerPoint presentation.
That's why I agree with Mr. Wilson.
Thank you.
It's by
All right,
agreement of the
so-
only reason it's coming in. Otherwise, it is hearsay.
I think Alessi started off. It was like he had a rough start, right? I think he had a rough start on his cross. I really do. Just I've kind of looked at it and I watched it a little bit. Some of the later guys had it on, Aussie and somebody else. And so I think he had a rough start. I mean, the problem with Welcher is, you're right, he won't shut up. He talks too much and he has to argue about every single thing. He has to equivocate. That has been the problem with the witnesses when they get on cross, is they all equivocate. Equivocate. That's the main word to use. It's all equivocation. It's all explanation. It's all adding stuff that they don't mean to.
In both the flash.
So, all right. So
2 slides are incorrect on the flash.
Okay, so we'll switch that.
Court of law, I think is what you're asking. Exactly the way you asked.
Is the Latin term for it is
there was a
basically
weird moment right at the beginning.
Scientific use. It's exactly
the way you asked. And so that applies to forensics. So my main job is
All right, so let's check this out. This was kind of weird when He first gets up on the stand, and Judd has to ask his name. What's your name?
What pleasantries and
What's your name?
vocabulary introduction?
Like this is some
we have
kind
today?
of moving myself around.
Robert Alessi,
Look at
sir.
that.
Robert Leslie, nice to meet you.
Nice to meet you.
So that right there was purposeful. That was purposeful. This guy has testified lots. He's a slime ball. He's going to tell them exactly what they want to hear. When he did his stupid paint thing yesterday, and I'll see if I can find that. When he did his paint thing yesterday, I saw something this morning that showed he moved his arm right at the last second to make sure that the blue paint got on his arm. Right? So let me see if I can find that. But that moment, when he says, "What's your name? I don't think we've met before." He doesn't introduce himself. He has Alessi introduce himself. He is trying to, it's kind of like he's the rooster, right? He's the king rooster. That is a dog lifting their leg to pee on a tree in that territory. That's a I'm an alpha kind of thing. That was meant to be a statement to set the stage on what kind of cross this was going to be and what kind of witness he was going to be. You can't convince me otherwise. That was a move. That was a purposeful move to set a boundary that I am going to be difficult. And it seems like, okay, it's just, getting it out of the way. But when you get on the stand and your immediate thing for the attorney is to ask them a question is weird. Okay. This guy is just a weirdo, but that's not how you do it. So you are making a stand right there when you start the questioning. So
Your whole name?
Robert Alessi, sir.
and not just your name, your whole name.
Introduction.
Dr. Walter.
Good morning.
What we have today?
Formally introduced. Your whole name?
Robert Alessi, sir.
Robert Leslie, nice to meet you.
Nice to meet you.
What the hell?
Dr. Welcher, the area in which you engage can also include, and I believe you used the term on direct, forensics, correct? Do you engage in any forensic activity in your profession?
Yes, the general umbrella of you basically coming in and giving scientific evidence in court applies to forensics. So my main job is action reconstruction and biomechanics. And so that's what I do. Sometimes it doesn't involve court. When it goes to court, that's generally forensics.
Right. So you're here today. That is my question. You're here today, at least in part, with regard to forensics, correct? Because forensics is the Latin term for it is basically you're going to have some type of presentation. It's for the law, correct? Would you agree with that? It's for law, forensics?
I mean, exactly the way you asked that, no. It's for engineering and it's for biomechanics. It's in the court of law, I think is what you're asking.
That's exactly it.
Okay, yeah, certainly for the court of law.
It ends up to a court of law in forensics.
No, not. You hear that? No. He had to, even though he agreed with Alessi, he has to give the negative
In part with regard to forensics, correct? Because forensics is the Latin term for it is basically you're going to have some type of court or jury presentation. It's for the law, correct? Would you agree with that? It's for law, forensics?
I mean, exactly the way you asked that, no. It's for engineering and it's for biomechanics. It's in the court of law, I think is what you're asking.
That's exactly it.
Okay, yeah, certainly for the court of law.
It ends up to a court of law, and forensics is a common term.
Yes,
so it relates to or it's used in or it's suitable for a court of law, the analysis. You'd agree with that as a general principle?
Yes.
Not a trick question. Okay. And so in forensics, what you're doing, among other things, is you're applying the scientific method and principles in here in a criminal matter, correct?
Yeah, you're trying to apply as much as possible.
Right. And so the primary goal of forensic science is to uncover.
So, all right. I got this here. No, not like that. This. And this was from Joe Flipperhead on X. Is a outstanding watch here. So I slowed down Welcher's overhead testing. He 1,000% rolls into the taillight after initial contact so he can get paint on his upper arm in an attempt to match JOK's bite marks. The arm is a ball and socket joint. It should move independently. 2 miles per hour would not cause this. So just
we have contact to the arm. I mean, first of all, it's a ball and socket joint. So the arm.
So yeah, you can see him start to roll his arm. I know his hat gets in the way, but look where that hits him, and then look how his arm starts to roll. Look at the cup. Look at the angle of the cup, and then the angle of the cup now. He is rolling his arm around there so he can
contact to the arm. I mean, first of all, it's a ball and socket joint. So the arm can move independently of the rest of the body. So with enough force, even if you're contracting your arm and trying to hold it out as tight as possible, it's going to overcome that muscular contraction and basically just move the arm.
Oh, Arca, they're going to crush that guy. I can't wait for that shit. All right.
The truth and to provide objective evidence that can be presented in court.
So now we're going to argue a
That
little
is generally
bit.
correct. Again, there are elements, for example, this analysis that are relying sort of on subjective evidence, like the testimonial, the witness statements. So it's not solely based, but ideally you'd want it as much as possible based on objective data.
So you would agree that truth and objective evidence is part of the presentation in terms of information
Yes.
for
No,
forensics?
yes, that's exactly it. That is exactly it. He is the smart one. He's the most intelligent. He's got all of the answers. You don't know what you're talking about. That's how he comes off to me. That's exactly how he comes off to me. He would not be the one to ask questions, right? He doesn't really care what you think.
In a court of law.
Certainly objective information, truth sometimes, again, can be subjective. Oh.
Truth can sometimes be subjective.
Truth and objective evidence is part of the presentation in terms of information for forensics in a court of law.
Certainly objective information, truth sometimes, again, can be subjective. Oh,
so you don't believe truth? You believe sometimes truth applies and sometimes it doesn't?
I want to. Okay, I want to see him. His reaction to that. I'm sorry. I got Emily pulled up to. Truth can. Yeah, and she of course she's got it marked.
as much as
There we go.
possible based on objective data.
So you would agree that true
objective evidence like the that is generally correct. Again, there are elements, for example, this analysis that are relying sort of on subjective evidence like the testimonial, the witness statements. So it's not solely based, but ideally you'd want it as much as possible based on objective data.
So you would agree that
Okay, so he hasn't even got to the truth can be subjective yet. She's already like, what the hell are you saying?
truth and objective evidence is part of the presentation in terms of information for forensics in a court of law.
Yes. Certainly objective information, truth sometimes, again, can be subjective.
Oh, so you don't believe truth? You believe sometimes truth applies and sometimes it doesn't?
If you know for a fact it is true, but if you take someone's deposition testimony, you have to look at it relative to the evidence, and it's either consistent with the evidence or not.
Okay, so now let's go to
See that he just the equivocation, everything equivocation, everything has to be equivocated. Oh yeah. All right, go back to.
You know for a fact it is true, but if you take someone's deposition testimony, you have to look at it relative to the evidence, and it's either consistent with the evidence or not.
Okay, so now let's go to your direct examination that you just went through. Hopefully this is fairly straightforward. You have testified to, and it's varied a bit, a reasonable degree of engineering certainty. Is that correct?
Correct.
You've also, have you used the word sometimes to reasonable degree of scientific certainty?
I might have.
Right. So
I don't know.
Right. In terms of your role as a biomechanical engineer and accident reconstructionist, is it important to engage in a critical analysis of the data?
Critical analysis, yeah, I think it's important to have a critical analysis. You want to try and look at it from all sides, consider all possibilities.
So it is therefore important to try to review the data as objectively as possible. You had mentioned sometimes subjectivity comes in, but I understand the goal is to try to look at it as objectively as possible, correct?
Correct.
Now, in your direct test, I've got it quoted. You don't have a dog in the fight. Is that what you said, sir?
I did.
And that you, quote, don't care, end quote, about the outcome. That's what you made a point of saying in the beginning.
That is 100% correct.
Now you simply follow the data. Is that correct?
I try to do that.
National Institute,
yes.
Generally, so the jury can understand what the scientific method is. Are you familiar?
Well, then we get into the scientific method and what it is, and he even has to argue about this.
There's one or two versions.
A general fair statement of the scientific method.
So for forensics, you'd have to add in the testimonial evidence aspect of it. So those are testimonial or things are in evidence. So frequently there's one or two versions, and you're trying to match which version is most consistent with the evidence.
Okay, adding that to what
No.
I stated.
They could both be wrong.
relative to NIST, you would agree that evaluation and testing of hypotheses.
Right. Yeah, exactly. Which one is the truth? Well, what if they're both? What if testimony? I mean, we've heard so much times, especially like eyewitness testimony. Eyewitness testimony is one of the most unreliable things that you can get. I mean, it really is, because our memories suck. And that's some of the things in this trial where people remember everything like it was yesterday on this thing, even though they've never said these statements until like 2 years later. Right. But yeah, you talk to some, right. Exactly. The go back to this trial and Jen and Carrie Roberts, Jen McCabe and Carrie Roberts have sat down. They sat down originally and wrote a timeline so they could remember all the stuff that happened. And so they talked to each other. And so they lived their shared memories. Carrie Roberts got called up to the stand or testified to the grand jury. Carrie Roberts said that she was standing by the door of the car and they were praying, and that Karen Reed said to Google hypothermia, Google how long, and this was her exact testimony. I remember it very vividly. Google hypothermia, Google how long, Google hypothermia. So that was what she said in the grand jury testimony. She started to say, Google how long to die in the cold. She thought better of it. And so she switched it to Google hypothermia again. She said in her testimony, I was right there by the door. We were praying and I heard Karen Reed say this. That was her grand jury testimony. It was 100% false. She did not hear it. She was told later that that is what happened. And because of the timeline that they created memories for each other. I'm sure there was other things that Carrie created memories in Jen McCabe's head. And I don't even, I think Jen is a very manipulative person. I think she probably planted way more in Carrie than Carrie planted in her. But, yeah, so now this guy is saying you have to put this testimony in there. Well, that's one obvious thing, that testimony is not, if the science is going to tell you, if the data, that's what Hank said, the data and the science is going to tell you that Karen Reed did this, right? And so now this guy's saying, well, the data and the science kind of says maybe it happened, but the testimony, you got to take that into account too. It's just, yeah.
And where possible, the selection of a final hypothesis is the scientific method, correct?
Generally, yes.
Is it correct that a proper biomechanical injury analysis utilizes a sound scientific methodology that's been subjected to peer reviewed and a publication that's been generally accepted in the engineering community?
Well, I can't. So this, I've done my analysis here, biomechanical analysis. I can't submit this analysis to peer review. I'm not allowed to give this to people outside the court. So there would be no way for me to submit my analysis for peer review.
More equivocation. Equivocation. I can't do that.
Forensic analysis in court generally never goes under.
And keep talking. Keep talking. Keep talking. Keep talking.
Peer review process. The methodologies underneath it, and looking at, like, for example, I think I referenced 25 papers in my report. That goes to the issue of trying to follow the science. 26.
So I think you maybe misunderstood my question.
And he grabs something to read from. And this will come up. This will come up. He grabs something to read from. He didn't ask if he could look at his report. He didn't ask anything. He just said, oh, he looked at something and said 26.
Sir, I was talking about your methodology, your biomechanical injury methodology. The methodology that you use and apply is to be subject to peer review and general acceptance in the engineering community. Is that correct?
So I have no way of publishing this analysis. So to get peer, I need to.
Go ahead and answer your question.
You're asked peer review, like you said, means I give it to my peers. I send it out to somebody to review for the scientific method. That's what the peer review process is. So I will gladly send this out to peer review with the court's permission, but I haven't and cannot do that.
Sir,
equivocation.
My question is not your analysis here in this case. My question.
So it gets that smug look on his face. It's like, oh, look, you don't know what you're talking about. I cannot send this analysis out.
The methodology that you use here is the methodology. You said 26 references, right? My question is simply, is the methodology that you use for your analysis in this matter, is the methodology for a proper biomechanical analysis, should that methodology be generally accepted in the engineering community?
I think with the forensic application, yes.
Okay, that was my question.
What even are these qualifications? What does that even mean? It's still science. It's not junk just because you're in court.
The scientific method that you've used in this case, part of the use of scientific method, the purpose is to avoid what is.
So, yeah, I mean, they get into it. He starts to go into confirmation bias.
And
Judd says, there's no way I had confirmation bias.
As well as neglecting evidence that contradicts those beliefs. Is that a fair statement of confirmation bias?
That is a statement. Yeah, it could be broader, but sure.
But you would agree that
He will not agree with anything. Yeah, no, that's good, but you could have said this.
Generally correct what confirmation bias is. And an example of confirmation bias is not considering alternative hypotheses once an initial hypothesis has been selected, even though data and information might contradict the initial hypothesis. Is that an example of confirmation bias?
That could be, yes.
And confirmation bias is
we got a yes out of that.
The scientific method. It's to be avoided, correct?
You would like to avoid it, yes.
Are you familiar with the term failure analysis?
Generally, you might need to define how you're using it for me.
Sure. So is failure analysis the enablement of science? So for you,
hold on a second. Generally, what you want to do is gather data.
When conducting an analysis of, say, an injury, is how did this happen? Is that one of the first few questions that you ask?
No, that's usually the last question.
Oh, so for you.
So hold on a second. Generally, what you want to do is gather data. You want to know what injuries there are, what evidence there is, like, for example, on the vehicles. And then the very last thing you want to know or define is, given all that information, how did it happen? So that's the end.
Well, you haven't asked the question yet.
Misunderstood my question.
You just gathered stuff.
I wasn't talking about the method or the process. I was talking about when you get to answering questions, whenever that is in process. Isn't one of the questions, and maybe one of the first questions, how did this happen?
No, that's not one of the first questions. One of the first questions is, where's the damage? What are the injuries? What's the evidence? What black box or text stream data do we have? What physical evidence was at the scene? So that is certainly not one. It is a question, but that question is at or near the end.
Isn't every one of the questions that you just mentioned part of the data gathering?
Correct. But when you're gathering data, you're always asking yourself questions along the way. Like, what is it? Where did it come from?
You've done.
You've
done collecting the data.
This guy, just everything is everything.
Massachusetts State Police has troopers who specialize in accident reconstruction, correct?
Yes.
And there are troopers within the Massachusetts State Police Collision Analysis and Reconstruction Section whose sole responsibility is to engage in accident reconstruction. Do you know that?
I do not know that.
Do you know that there are troopers within the Massachusetts State Police Collision Analysis and Reconstruction Section who engage in accident reconstruction?
Just based on what I've seen in this case.
Right, based upon what you've seen in the case, that's
enough.
Thursday.
And I just know that those people are doing it.
Are you familiar with a Massachusetts state trooper named Joseph Paul, P-A-U-L?
Yes.
And you
Well,
know,
I'm familiar with his reports. I don't know the man.
Okay, familiar with Trooper Paul through his reports in this case, correct?
Correct.
And
I thought he was. I was reaching for a report. He grabbed his water
he
instead.
was assigned by lead investigator, former Trooper Michael Proctor, to be a constructionist in this case on January 29th of 2022, as evidenced by that report or those reports of Trooper Paul. Do you know that?
Well, you put a lot of things in there. I know he issued a reconstruction report. I don't know who told him to do it. So the first party question, I don't know, but I did see a reconstruction report from him.
You were retained. So do you recall, is the date January 29th of 2022? Is that a rough time period of him being assigned, or you don't know when he was assigned?
Don't know. That might have been in his report, but I wouldn't have paid attention to when he received an assignment.
Do you know when the date of the first report of Trooper Joseph Paul? You know that the date of the incident in question is January 29th, 2022, correct?
Correct.
Not January 30th, like goofball. Man, Shannon had in his report. Okay, so they just do this a little bit. This is kind of laying some foundation, is all this is. Then we get into billing, and of course,
Do you believe Aperture is working for free in this matter?
Oh, no, I don't believe that. No,
So
we're an engineering company. We bill for our time.
So you know that Aperture is getting paid for its work in this case, correct?
We are billing for our analysis work.
Well, you're not.
can't just answer yes. You have to equivocate. Equivocate, equivocate, equivocate.
So I have not seen any of the payments. I would assume that we're getting paid, but I don't know that.
Sir, you are a senior vice president of Aperture, are you not?
I am.
You would know, wouldn't you, if
I don't do that.
your firm was not.
No, probably not. Usually it takes, 9, 10, 12 months of not getting paid before the accounting department reaches out to me.
Exactly. So you've been on this for 2.5 years. So if it would take 9 months or 12
Well,
months.
this right here was a kind of a bump for Alessi because he was not. He's been on this 9 months. The accident happened 2.5 years ago, but Aperture hasn't been on here 2.5 years. So this is kind of
I'm sorry, sir.
this is kind of an own goal.
Question of payment.
Hold on. You said I've been on this case for 2.5 years. I was retained in September 17th-ish of 2024. So that's less than a year ago.
Understood. I'm moving on to the next question because I want to move away from that discussion and just go right to the bill.
Part of that process. We have an accounting department. I don't.
Obligation of the Commonwealth, your firm does work and the Commonwealth pays for it, correct?
That's the idea.
Right. And so you know about that contract because you signed it.
Correct.
Then they argue about the contract.
No.
He wants to get to how much they're paying for this.
Of a Lexus exemplar for your testing?
Correct.
Who pays
So they bought a $95,000.
And is that then cost passed on to the Commonwealth?
No.
So you pay for the Lexus. You don't pass that cost on, correct?
So what we're doing is we pay for the Lexus. We're keeping it till the trial's over. We're selling it and charging the Commonwealth the difference in the price.
Exactly. That was where I was going, sir. So,
but they're only paying the difference. So, and in theory, if we sell for more in California, then we'll reduce the bill.
Okay, I don't want to speculate. I just wanted to see what the obligation was. So
the obligation is the difference.
Exactly. So the obligation is the difference.
So the Commonwealth's paying for the Lexus? No. So how does that work? Well, once the case is over, we'll sell it, and then the Commonwealth will pay the difference. Well, that means they're responsible for the Lexus. See, everything in equivocation.
Are you aware that on April 5th, 2000?
So, all right. So
to be paid to Aperture. Isn't that what that amendment contract states?
I believe that's correct.
So the Commonwealth is 24.
Oh, now they're
talking about dates.
talking about
6 months that your firm's been retained. Did I have your answer correct about how long you've been on it?
I guess it's closer to 8 months.
All right, so 8 months. So for 8 months.
So, yep, back and forth. More contract.
On the maximum obligation of the contract pursuant to this contract. Without saying what it is, just does it refresh your recollection?
No, but I don't have any reason to believe it's not correct.
Okay,
I was going to try and answer his question.
Started
All right,
approximately April 22nd of 2024.
Okay.
Did you create your updated presentation before or after?
So look at him. He's got his computer on. His computer is on right now.
That you created it?
I still don't know without looking at the document.
So now they're talking about when did you create the document?
My question, sir, is this. The updated presentation, we'll get to the changes later, but the updated presentation, you created just how many days ago?
I'm going to say weeks ago.
Weeks, 2 weeks?
I don't actually know without looking at the documents.
What was it, more than 3 weeks ago that you created it?
I still don't know without looking at the documents.
Do you know when the trial started in this matter, sir?
I do not.
Assume the trial started approximately April 22nd of 2024.
Okay.
Did you create your updated
There he
presentation
goes.
before or after April 22nd of 2024?
I don't know.
What would you need to look at to refresh the recollection?
Do you know when?
Hold on one second. Dr. Welch, I'd ask that you not do.
Not looking. Okay, I was going to try and answer his question. My apologies. I will shut it down.
Thank you.
You're welcome.
Shut up.
If I may, Your Honor. please
You're
say-
welcome. That's pissing Bev off. She's like, this is my court, bitch.
Are you able to determine when you created the updated presentation?
I think so. That's what I was attempting
Your
to do.
Honor, may he do that?
Yes, I'm going to see Counsel Diver while you pull that up,
Thank you.
please.
So we did get a little giggle out of Bev because she said she told him, turn it off, put it down, and then he's like, can he look at it? So yeah, so then they go to sidebar about this, and I think they're in sidebar for a little while.
Defense, that was something
Oh, nope.
First Amendment made.
So yesterday.
Okay, good. Now, the version.
Okay, so this is kind of now they're back.
Don't even on that, my lord. Maximum obligation will be paid. Still dealing
This is
with
kind of
these- that
crazy.
whole part.
This is another back and forth
so
equivocation.
something-
I don't know.
Tell us more.
I never
Can you
did
tell us more about the
this.
bad that
For Mr. I need you over there. So, and once you get that answer,
Oh, and I think I want to switch to. Let's switch. Okay. Let's get to that. I think this is it.
Without saying referred. There are times
you need
he needs to be told to not read his.
I'm going to ask you to shut your computer down,
Oh.
or at least put down the cover. Thank you. All right, so you can answer.
And the
Mr.
court has
Russ's
shut it down. You need to put down. You need to put
this
down the
up.
laptop cover. You
Speedy,
can't just
speedy,
read it in.
speedy.
I said this with Don Hughes too. Of here and do this.
Yes. When did you create
So
the
improper.
updated presentation that you reviewed in your direct testimony?
So that addition I made was taken out. It wasn't in my direct
Sir,
testimony.
If you can just hear my question.
Equivocation.
It's this. The version of the presentation that you put on the screen, when did you create that version? I'm just looking for a date.
So to answer your question about the version on the screen, I created that yesterday when the judge asked me to take off some of the headers. So yesterday.
Okay, good. Now, the version before that,
The redacted.
that you created yesterday, when did you create that version?
The day before.
And then the version before that.
So what he's going to do, what we're about to watch, is he is about to blame the defense for this whole thing. Like, well, I took this out because that's what the court said, right? I took this out. I'm hoping the jury caught this because, again, he can't answer anything correct. What it turns out is he got while the trial's going on, the prosecution sent him this clip of Karen Reed saying something about an alternate route. He put that in his presentation. He's having conversations with the prosecution about it. The defense says, no, you can't do that. So they eventually get it out, but he's going to try and blame the defense for this, even though it was the prosecution that started this whole thing by sending them a clip that he says was new information. That's actually not new information. It's old information. The clip's been out there forever. So it's just a mess. I mean, this whole thing takes way longer than it should. And he tries to blame the defense. It's nuts.
I mean, I save it every day.
Understood.
So
every day.
Keep
So you
updating
change
it.
the presentation every day.
This is not what experts are supposed to be doing. And we've gotten now to it's every day, bro. Will this matter to the jury? Maybe not. Because the jury is not sitting here from lawyer perspective going, there are expert disclosure periods. And once the expert disclosure period is done, it stops. It's not like it's every day until 3 minutes before you walk.
Since when?
No, I don't think I've changed the presentation every day.
That's my question.
My question is, how many times have you changed it within the last 2 weeks?
So look at he even asked him. He said, "How many times have you changed it?" I don't know.
No, I don't think I've changed the presentation
Like-
today.
That's my question. My question is,
He said every day. He just said I changed it every day, and now he's saying, "No, I don't think I did change it
times have
every
you
day."
changed it within the last 2
Saving
weeks?
it every day. Don't change it every day.
Your presentation.
Let me try and cut to the chase here. Sure. That slide was added on May 13th, and then it was taken out before I presented it here, so it was not in my presentation here.
So he's saying that slide, that video about the alternate path was taken out because the defense said.
So here's the question.
May 13th? I think May 13th was
Your
the answer.
first version, as I understand it, of the slide presentation was January 30th, 2025. Is
Yes.
that correct?
Correct.
When was the 30th, 2025 that you changed that presentation?
May 13th.
Okay, that was clear.
So January 30th, 2025, it's been submitted to the court. It's been submitted to the defense. And then on May 13th, after we've been in trial for 4 weeks, he changes it.
Assuming the trial started
Burgess, right?
April 22nd of 2025, you changed your PowerPoint presentation
While you were in trial.
during this trial, correct?
Yes, correct. Correct.
And how many times did you change your presentation after April 22nd of 2025?
Well, the last time I changed it was like 10 minutes ago. So in response to various discussions, I've been making continuous changes to it.
I want to make sure you finish your answer so I didn't
No,
you're on the
I'm not
stand.
sure how much granularity you want to that answer.
Great. So
Thank you to everyone in the chat.
created on January.
To everyone in the chat that is refraining from just screaming and calling this witness names, I appreciate you.
Oh, the original one. Sorry, January 30th, modified May 13th.
Right. If I could finish my question, I might be able to shortcut this. Thank you. So you created the original one on January 30th, 2025. You made your
Y'all are
first
doing it.
amendment May 13th of 2025. And then before you sat for your testimony, which was yesterday, correct? That was the first time you sat for your testimony.
Y'all just mobile gaming.
I was here yesterday.
Days get foggy when we're in a courtroom, but it was yesterday. How many times
700
did
years
you
ago,
change your
lies.
presentation from January 30th, 2025 until when you first walked in the courthouse yesterday?
Do you mind if I count?
Not at all.
So there was the May 13th change. Half of that was in response to objections from the defense. I had to add all the paths to where everything was. Then when I got out here, Mr. Brandon asked me to take out references to evidence about statements that I was not allowed to present. So that was within the last 3 days. And then I've modified it a couple times today based on rulings from the judge.
Okay. Let's break that down.
No, Alessi, that is a clear answer to a clear question. I think it's time for the judge's ruling. That's fine. The modification they're talking about. The other modifications were redactions from the court and Brandon. Okay, fine.
You what? Because I want to know about the other half.
Sure, there was two changes. I added the extra path of 138, and then I was told that the defense was having problems with my PowerPoint, so I had to go in and add the
He's just
paths
throwing
to
that
every
in.
single slide
I changed it
about where
because
the
of
evidence
you.
came from.
Yeah.
They were saying I didn't provide
It's
everything.
your fault.
I had to provide everything.
I changed it because of you.
So
That was the second half.
Got it. I want to go to the first half, sir.
Sure.
You
I'm
get what you
gonna
asked for,
try to shortcut this,
defense.
and if I'm not clear, you just let me know. I want to talk about the first half.
I put on hand
You
lotion
called
now,
it. I didn't hear it. It was like, did you say path?
Path.
P-A-T-H?
Correct. The path Miss Reed was driving.
Right. What you made the change for May 13th, that first half, that wasn't something that was triggered by the defense. That was something irrespective of the defense, correct?
It was based upon her statements. Is she part of the defense?
All right, so that's what I wanted to get to. You changed the first half based upon statements allege that Ms. Reed made. Is that correct?
Because I changed one slide. There was 130 slides originally.
You got the report. I only changed one slide. I just, slipped that in there because of statements that I found out that the defendant made. She's part of the defense, right? So you could call her part of the defense. I mean, granted, she does really participate in her own defense very, very aggressively, I guess we would say. She is a big part of her own defense. She really is. And some people are not happy with it, especially the people that think she is guilty. They hate the fact that she and these are some of the best defense attorneys in the nation. If they value her input like it seems they do, because she catches things, then that's great. And these people that say stuff like, "Oh, she's got them on a string," and I can't believe that it's crazy. It's crazy. You see the stuff on X that comes out. It's nuts.
Or something like that. So half of the changes on that day, which was one slide, I added one line to the bottom of the previous slide.
Did you consider that change significant?
No.
Well, then why did you make it in the middle of trial if it wasn't significant? Why didn't you just leave it off and then discuss it in terms of testimony?
Warning.
So, A, it ultimately was left off. B, because it was
Oh, ultimately, I left off. I took it back off. Well,
insignificant, and I didn't need to have it. So the way it got presented was exactly the way it was before May 13th. So it didn't change anything.
But it was significant enough for you to make a change to your presentation, correct?
So my goal is to be as accurate as possible. So when I saw the path that I gave the way she could drive, I gave the possible paths. That was one of the possible paths that hadn't originally been included. So in striving to be as accurate as possible, including as much information as I could, I wanted to make sure I included that.
That's a reasonable explanation.
You were striving. The clip that you used to make the change, you say you made the change based upon a clip you observed with regard to Ms. Reed. Is that correct?
I believe that, yes, that is correct.
Do you know that clip has been in existence for months?
I don't believe I got it until April.
Really?
So a clip that has been, assume the clip's been in existence for
so
months.
What's funny here is Emily's saying, okay, move on. This is a catch right here. This is a trap that he's falling into. And I think she's going to appreciate this. I don't remember this from this morning. I think she's going to appreciate this because he admits that it was from the prosecution is the reason he included this in the slide presentation. So let's just see.
Dr. Welch, I have to ask you not to refer to
I'm trying to be helpful.
Close your computer.
Let me close it. Sorry.
And again, sitting on the stand, reading from your computer is crazy.
I was trying to answer his question.
The man can't stop opening his computer. I'm glad the court called him on it. The court, he's like, no, I'm trying to find the info. You're testifying on the stand. You don't get to just keep scrolling through your computer. Somebody take it off the stand. Just take it.
Please.
Your Honor, yeet his computer. Well, and explained it well. He's like, right, because the defense wanted me to change it, so I took it out. And if Alessi keeps banging on about it, doesn't know about the disclosure, is just hammering him on looking at his computer, though.
So assume the clip.
It's embarrassing as an expert to be told to stop.
Said was the basis for changing your PowerPoint on May 13th after the trial started. Had been in existence for months. You just got that clip, you say, in April?
I believe so, yes.
What was tell me the circumstances by which you got the clip. Did you ask for it?
I was told there was a new interview.
Okay. Who initiated the conversation about the new interview?
I don't know if it was Mr. Brannon.
It was someone associated with prosecution?
Yes, I wouldn't have known about it.
Exactly.
It's the Dateline, not the Dateline, the Discovery ID. When did that air? That aired in April.
About this clip.
Right?
I need to look, but I remember it being about mid-April.
It aired right around then.
If I'm thinking of the correct clip.
What were you asked to do, if anything, with regard to that clip?
When I got the clip, I wasn't asked to do anything.
What did you do with the clip once you got it?
So
it
they
aired March
then
17th.
indicated there was this suggestion of an alternative route.
Body in the Snow from Discovery ID aired part 1 March 17th until it was turned over in April.
The alternative route.
So it was suggested to you by the prosecution that you look at the clip and they pointed out that there was an alternative route they wanted you to look at?
So I took it to be, we have additional evidence.
Right, there's more
Please look at the
information.
additional evidence and add it to your analysis.
That's fair. New info can get included. He said that on direct.
Yeah, but there's
On the topic of additional...
there's supposed to be experts aren't supposed to know what's going on in the testimony. They didn't even, they took it out eventually, but still it's changing this thing.
The Commonwealth?
Yes, we had a discussion before that he had found new information that changed the timing.
What?
Okay, so then they get into Burgess's thing.
Right?
Correct.
So this Burgess's change.
Intending to submit that May 8th report to the Commonwealth?
Yes, we had a discussion before that he had found new information that changed the timing.
What?
Oh, he had found...
Oh, this is so bad. Burgess found new information that changed the timing, but it wasn't new information. It's been there all the time. He needed it to all match up with the prosecution, and because Whiffen testified, the lock of the cell phone happens before the impact. then you have to change your timeline. And this is a mess. This is just a mess.
Oh, you had a discussion about new information?
New information as opposed to the information always existed. It's just it was pointed out to him that that should be looked at. What's the basis of your understanding that he found new information?
No,
that to allow the question, but you have to ask it differently.
I will, Your Honor. Thank you.
And the court overruled the objection from the prosecution to the question.
What is the basis for the statement you made that Mr. Burgess
Yeah, that's a better
found
question.
new information?
Yeah, why? How do you?
I guess it was his meeting in our discussions. He indicated that he had found new information.
Did you ask him? What do you mean by new?
No, I took it at what it said.
So, do you, as you sit here today, have any basis to say that that information is new as opposed to it's always been in existence?
Yes.
What is that?
What he told me.
Oh, so you relied upon.
Oh my God. Do you have any information that this is actually new information? Well, yeah. Okay, what is that? Well, he told me. He said it was new. It's been there the whole time.
Mr. Burgess,
Oh
you
my
have an
God.
independent document to determine whether, in fact, it was new.
Correct. I don't quite frankly care whether it's new or not. I just care what's in the data. Whether it's new, old, I don't care. It's not relevant to what I'm doing.
I don't care. I don't care if it's new, old data. I just, if it makes my timeline fit better, then I got to use it.
I don't say this is new data, this is old data. I just care what the data is.
Sir,
frankly, my darling, he does not give a damn.
has Aperture ever submitted a report, a changed report in the middle of a trial to your knowledge?
I have no idea.
Do you know whether Aperture has ever submitted an amended report?
All of you, not all of you, a lot of you asked me earlier, can the defense get into things like disclosure deadlines and discovery rules? And 55 seconds ago, I would have said no. But if there are deadlines for things, do you care about the deadline?
Only certain courts and certain legal systems require reports. But for example, rebuttal, analyzing testimony that comes up in court, getting trial transcripts. I very frequently have.
Sir, my question is, as you sit here now, can you state one court case where you or Aperture has submitted an amended report in the middle of a trial?
I cannot speak.
He basically said, can you name one court case where you or Aperture have changed a report in the middle of trial? That was the question. If you can't hear it.
Aperture has submitted an amended report in the middle of a trial.
I cannot speak for Aperture. I can only speak for myself.
Can you answer? Oh, speak for yourself, sir. Can you then?
It was compound, Leslie.
Any instance where you submitted an amended report in the middle of a trial?
Amended reports? No. Amended analysis? Yes.
Thank you.
Every answer an equivocation. Every answer equivocation. Every single time. So, all right. We go to break. This is insane. We go to break. During the break, we come back for break. Here we go.
That I wish I didn't have to address.
Dr. Welcher was just using, at least my observation, his computer. He still has monitors on his desk. Can we have all that removed, Your Honor?
Yes.
Closed.
Sigh. You hear the sigh? Like he's like, oh. No, I have never worked for the FBI. No.
An administrative matter that I wish I didn't have to address.
Dr. Welcher was just using, at
No.
least my observation, his computer. He still has monitors on his desk. Can we have all that removed, Your Honor?
Yes.
Closed. Yes.
Did he open?
So did you just turn it off?
No, but I will. If I close it.
It's preposterous.
Like want the computer all the way off or just everything?
Is he going to need to turn his computer back on?
I do not see a need for the computer to be turned on.
They have his PowerPoint. He doesn't need his computer on. He just keeps going back to it.
This should have been done before the jury came back. And Alessi is right. This has been an ongoing issue. This is why most experts will bring a binder or printout of their presentation and not be operating it from their own devices.
And this guy just sits there. I'm gonna go to my computer.
Go watch how I felt about Dr. Hughes doing the same thing.
Oh my God.
My distaste for expert.
Like, I know it takes a while to set up in the morning. We're going to actually take all that down.
Take it down now.
Okay.
No, Your Honor, fuck it. Make him take it down now. My distaste for expert.
Lunch break, I'll actually remove those monitors. Okay.
I'm sorry?
During the lunch break, I know it takes you a while to set up in the morning. We're going to actually take all that down.
Take it down now.
Okay.
No, Your Honor, fuck it. Make him take it down now. Take it down now. Take away his toys. This man just keeps going back to the tech.
Are you aware that the defense counsel received your amended PowerPoint presentation at 3 p.m. on Memorial Day?
I'm sure he's not aware of that.
No.
Okay, and now the jury's aware.
So now the jury's aware. Yeah, exactly. So, all right. So then we start getting into some of the data, and this is kind of this is a rough section, and I know this is something that I have been speculating on, and for some reason he's not able to get it in. He's not able to get this information into the thing, and I some of the voir dire that happened this evening is related to this, I do believe, to try to get this in. And the defense is going to say that the 1162 key cycle is not the key cycle that they think it is. It's not the key cycle of when they left the waterfall and drove to 34 Fairview, and then Karen drove back to 1 Meadows. The defense is going to say that was a different key cycle. And so during this section, unless he tries to get this in, and I think we'll just go back to Andrea. I want to listen to this. So we start get into this.
Which is why you frequently have different ignition cycles versus key cycles in EDRs compared to a little bit different.
So let's go back
I'm not
just a little bit.
asking a question. So if it's yes or no, I'm fine with that.
EDR.
Switch topics.
Okay.
One of the goals of apertures analysis and reconstruction.
Right back. I'm going to grab a water and
timing of certain tech stream events. Correct.
Correct.
EDR data.
I'm sorry, my role.
Your role. Yes. EDR, and just for clarification, EDR is event data recorder. Correct.
Correct.
So I'm going to refer to that, as you have before, as EDR, event data recorder.
Sounds good.
EDR data does not show the location associated with a tech stream event. Correct.
In this particular vehicle, it does not.
And the EDR data for this particular vehicle, namely the Lexus SUV, also does not provide the time associated with a tech stream event, correct?
Not at the time of this event.
So the answer is no, correct?
That is not correct.
So let me ask the question a slightly different way. The
argue about nothing
Always
again?
got to argue. Always got to argue.
Does not provide the time. The EDR data for the Lexus SUV that you've been talking about does not provide the time associated with a tech stream event, correct?
That is correct.
Instead, every tech stream event is associated with a particular key cycle on the vehicle, right?
Correct.
There can be multiple tech stream events in a single key cycle, right?
Correct.
And every time you start the car, this is when you push the button, that's a new key cycle, right?
That will cause a key cycle.
And the EDR data indicates the number
What
of
else
seconds
causes
into
it?
the key cycle.
What else causes a key
particular
cycle?
event occurred, correct?
The EDR data, no.
So EDR data gives you no information about the number of seconds into the key cycle that a particular event occurred.
You're confusing EDR data and tech stream.
I'm not, sir, I'm just
I'm
asking
not.
a question. So
So
if it's yes or no, I'm fine with that.
EDR data will, depending on the vehicle, sometimes it has information about GPS date and time. Sometimes it has ignition cycles, which are a little bit different than key
You don't
cycles.
care about other vehicles.
Which is why you frequently have different ignition cycles versus key cycles in EDRs compared to tech stream.
So let me ask it a different way.
Okay.
The tech stream data indicates the number of seconds into the key cycle that a particular event occurs.
Yes.
Is that correct?
That is correct.
In order to properly determine the location and the timing of a tech stream event, it's important that you correctly identify the trip that is associated with a particular key cycle, correct?
I think I'm going to say yes. The tech stream tells you the trip.
I'm just asking if it's important.
So he is trying to get out of him right here that you have to have outside, and I think Alessi is trying to do it within the realm, because so he's lying. You have to lay foundation. There has to be foundation for all of your questions, right? And so I think the foundation was in when they brought all this in to begin with, and they're saying that the 1162 key cycle is the event key cycle, the event or the event at 34 Fairview. So with whatever happened, they're going to try and argue that's a different key cycle for the trip from the Waterfall and CF McCarthy's to 34 Fairview and then the 1 Meadows. But he needs to get that in, that there has to be outside influences. You have to have a additional data. Like the reason they're saying that 1162 is what it is because they said, okay, that the car was on for this long. The car was on for this long from going from CF McCarthy's to 34 Fairview to 1 Meadows. And the car did this 3-point turn when they were on Cedar Crest. And so what they're saying is this data from John O'Keefe's phone matches up to this supposed 3-point turn at Meadows Road, not Meadows Road, of Cedar Crest. And so you have to have outside information to get what key cycle does what, and then what event is triggered, which the 1162, backing event is triggered. So if you have misidentified the key cycle, then you have an issue. Now, if the 1162 is something different, because in the last trial, the state claimed that 1164 key cycle was the Trooper Paul had the car. The car was in the custody of the state of Massachusetts from 1164 key cycle on. If that's the case, 1162 key cycle could not be the right one. 1162 would probably be them picking it up. So the problem is he runs into issues. He runs into not being able to get this information in.
Identify the trip associated with a particular key cycle, and do so by determining, in order to properly determine the location and timing of a text stream event.
So the text stream tells you the trigger event and it tells you the key cycle. So I'm not determining that. I'm reading that from the text stream data.
Okay. So in order to properly read, to use your verb, the location and timing of a text stream event, it's important that you correctly identify the trip that is associated with a particular key cycle. Is that a fair statement?
I think that's a fair statement.
If you associate the wrong trip with the wrong key cycle, then your estimate of when the text stream event occurred will be wrong, correct?
It can. I mean, you need to take the totality of the evidence.
The totality of the evidence now is
the
a
mileage,
disclaimer?
the overall timing into account.
So are you saying, sir,
So yeah,
that if you have the wrong trip with the wrong key cycle, you can get the correct text stream event?
No, not necessarily. Again, you have to take the totality of the data.
This guy is now saying nothing.
My
He's saying
question
nothing at all.
is with regard to if you have the wrong trip
Oh,
with the wrong key cycle, then your estimate of when the text stream event occurred will also be wrong. Isn't that just a matter of logic, sir?
So again, the text stream event tells you the trip.
So he knows, this guy is smart enough to know what Alessi is trying to do. He knows, probably come up in conversations with the prosecution, right? So, and I'm going to say this guy he's smart. He's not a dummy. He knows what Alessi is trying to get at here. So he's going to make super equivocation. He's going to say a whole bunch of words that don't really mean something because he knows where this is going. He knows where this is going.
If you're saying I'm associating that with the wrong infotainment information or vice versa, then that would be wrong. But the text stream data tells you how much time is associated with each trip. There's no difference there.
If you associate the wrong trip with the wrong key cycle, then your estimate of where the text stream event occurred will be wrong. Is that correct?
You can't associate the wrong event with the wrong key cycle because it keys in the key cycle with the event.
He's arguing over the wrong words. Nobody's arguing about the event and
Let
the
me
key
try
cycle.
a different way. Your analysis or anyone's analysis,
Weaponized stupidity right here.
in conclusions regarding the timing and the location of the text stream data are only as good as your ability to correctly associate a key cycle with a particular event. Is that an accurate statement?
No. Again, you need to take the totality of the data. So that is one element. You need to look, for example, at the mileage.
But I do think Alessi probably could have. He's trying to be careful. He's got to word it right. Brendan is going to object. Bev is going to sustain his objection, which we see happen here. And I think we're going to get back into this tomorrow. But this is tough because he's got to lay it down.
So are you saying that you can have an incorrect key cycle with a particular trip, but you can still get accurate timing and location of text stream data?
So again, you don't get incorrect key cycle with the trip. The trip and the key cycle are coded in by the text stream. If you are attributing an event to the wrong trip, which has a fixed key cycle, that could be a problem.
Exactly. So if we could go, if Your Honor, if we could publish a slide, please, that is in evidence.
Okay.
Thank you.
What are we looking at?
Pardon
What
me?
slide number?
I've got slide 9. You viewed the vehicle control history on September 23rd of 2024, correct?
In addition to the PCS data.
You viewed the vehicle control history on September 23rd, 2000.
See, that.
I'm going to use the acronym VCH that you've used on your, do you recall using the acronym VCH on your direct testimony?
Everything in equivocation. This guy cannot say yes or no. He asked him a specific yes or no question. And he has to interject some. He won't even say yes and then interject. He just interjects the part that makes no sense whatsoever.
Yes, sir.
And VCH
No
stands
sense.
for vehicle control history, correct?
Correct.
You viewed the vehicle control history on September 23rd of 2024, correct?
In addition to the PCS data.
So he has to ask it again. He has to ask the question a second time.
You viewed the vehicle control history on September 23rd, 2024. Yes?
That is yes.
You took photographs of the vehicle control history, including key cycle 1167?
Correct.
And in this screenshot, we can see 4 text stream events.
Actually, can you zoom in on the key cycle?
Oh, sure.
Sure. Why, yes, we can.
I think when I got to, no, scroll. So when I got to it, you can see it was at key cycle 12.
Well, here he is taking control, right? This is another P on the tree right here. This is another mark in his territory. I am going to take control. Can you zoom in? Can you do this? It's just little things, but he's trying to assert dominance.
1264. The blue highlight was the last file that was written on key cycle 1167.
Right.
So to answer your question, I got
There's
it at
been 100
1264.
key cycles?
So we can go back so we can see the 4 text stream events. I just want to reestablish the foundation here. In this screenshot, we can see 4 text stream events that are associated with key cycle 1167, correct?
Correct.
But isn't it true, Dr. Welcher, that there were actually 10 text stream events associated with just that one key cycle 1167?
Correct. I gave you the original files.
Right. So you are
Another
aware
equivocation.
that the Commonwealth
Equivocation.
has maintained up into your firm's engagement.
All right, so now this is where he's trying to get this in. He's trying to say that the Commonwealth said up until Welcher took over, up until Aperture took over, they were trying to say that 1164, 1165, 1167, it's coming up right here, that those happened while the vehicle was in custody.
Are you saying there's no basis for the question?
Yes, sir.
All right, I'm going to allow the question and I'll hear it.
You are aware that the Commonwealth has maintained up until your engagement in September of 2024 that all text stream events associated with key cycles 1164, 1165, and 1167 occurred while the Lexus was in the custody of the Massachusetts State Police at the Canton Police Department.
Okay. So the objection sustained. You need a foundation, Mr. Lessie.
That's what he's trying to get in as the foundation. See, that's the issue here, is laying the foundation that 1162 is not the key cycle, but he just gets shut down.
In your review of the many documents that you referenced on your direct examination,
What you staring
did
at
you
there?
review the text stream events associated with a Lexus SUV?
I reviewed the one I downloaded.
Pardon me?
I reviewed the one I downloaded.
Right. And did that, what you download, include key cycles 1164? Did it include that?
It did.
Did it include 1165?
It did.
And did it include 1167?
It did. It did not include 1166.
I didn't mention 1166, sir. I only mentioned 1164, 1164.
Always got to throw something else in there. Every single time I'm going to throw in another detail that you need to know. It's like he's saying, Mr. Lessie, I appreciate your question. I really do. But you're not getting the entire story. So let me help you. And in fact, at one point, he does say, I'm trying to help you. Oh, we'll get to that. It's so condescending.
I purposefully skipped because I didn't understand you had reviewed it. So here's my question. You therefore, based upon the fact that you reviewed them, and you said it's important to understand timing, etc. That's very important in your forensic analysis, correct?
Yes, sir.
So let's go to the timing question and you understand where the Lexus has been at various points in time. You testified to that in direct, whether it was at the Canton Police Department, whether it was being towed, correct?
In addition to having Mr. Burgess' analysis of the data.
In addition to Mr. Burgess' analysis, so in that analysis contained locations of where the Lexus had been.
It contained where it had been and also include date and time, when it was turned on, when it was turned off.
Exactly. So not only did you have all the locations, you had dates and times associated with the location where the Lexus SUV had been, correct?
Correct.
Now to the question. Based upon those bases, you're aware, and you've reviewed, by the way, Trooper Paul's reports, correct?
I have.
There were two reports of Trooper Paul. There was his original cards report and then a supplemental report that were listed in the documents you reviewed. Do you recall that?
I don't recall that, but I'll take your word for it.
I don't want you to have to take my word. Do you recall, sir,
No,
that there were do you recall that there was a report of Trooper Paul?
Yes.
Okay, and you read that report, I assume, sir?
I did.
And it would be important for you to read that report and read it carefully because it addressed the subject matter that you were addressing, correct?
No, I did my own independent analysis. As a matter of fact, it'd probably be more important that I don't do that to avoid confirmational bias.
But you did read Trooper Paul's report.
Of course.
So
Yeah, so this guy's going to try and say that he had no idea that they thought 1164 was when they picked up the car. So that does not account for. Let's just go through it. And I don't know if Sleuthy's I don't know if her spreadsheet has the key cycle stuff in there. I'm going to see real quick because 1162 is what they're saying is the key cycle where everything happened. And 1164 is when they had control of the vehicle. So 1162, if that's the thing, then they go over 1163 would be the next morning, right? So she goes to One Meadows. She parks in the garage. 1163 would be her backing the car out of the garage, backing into the GMC of John O'Keefe and going to Jen McCabe's house. Now, did she shut down the car at Jen McCabe's house? Not sure. We'll say for posterity, she did not. That's key cycle 1164. 1164 would be when they come and they take the car from One Meadows to Dighton. Then 1165 should be when they pick up the car in Dighton and load it on the flatbed. So there's no way that 1164 is when the Commonwealth took the car. It's just not possible. There were more key cycles than what they're accounting for. So
you therefore are aware that the Commonwealth has maintained up into your engagement.
Yeah, I'm going to see a tie bar on this.
That seems like pretty good. Just a mess. I like Alessi is cracking the whip a little bit. I didn't ask you about 1166. He's going to go ahead and volunteer. See how he's being very careful with words when he wants to quit.
Oh,
This is what's going back to what we were talking
quite a
about.
long
when I was like,
sidebar here.
Are you aware that over the course of the Commonwealth's and your investigation
before? So it was on Keysight. This 100 times.
May I, Your Honor?
Yes.
Thank you. Are you aware that over
back into
the
it.
course of the Commonwealth's and your investigation into this case, that the theorized time of the alleged contact of the SUV?
So just two words, just strike theorized.
Okay. Thank you.
Hello, Siren. You don't object before the question is out.
Can I
Go
begin
ahead
my
and
question?
ask an appropriate question, Mr.
Ask an appropriate question.
Lord.
Totally fine for the jury to hear that.
Do you have knowledge whether there is one time or more than one time for the Commonwealth's position, as you know it from reading documents, that you say.
So now he's got, this is the problem with this, is now he gets really, really bogged down in this, and it's really hard.
That there are
He's trying to lay the foundation properly. Bev's not giving him any room at all.
different times
And
alleged
so-
for the incident to have occurred at 34 Fairview. Objection.
Sustained. You can ask the question, remove part.
I'm sorry,
You have to remove part.
I wanted to say alleged by the Commonwealth.
I'm not giving the instruction now.
Dr. Welcher,
All right, so
that has been proposed by the Commonwealth for the impact alleged to have occurred at 34 Fairview. Objection.
Sustained.
Doesn't wanted to say alleged by the Commonwealth.
I'm not giving the instruction now.
Dr. Welcher,
What instruction?
in
this
terms
is
of
crazy. I mean, if that was their hypothesis, then and that's what they even wrote the report on, he can bring it
What's
up.
the problem, Bev? Is
That's
the
freaking, that's just ridiculous.
impact at 34 Fairview. Objection.
I'm going to see you again, folks. I'm sorry.
This is so ridiculous.
forgetting to mute the time. The you're gonna get some kind of instruction at some point. I don't know.
Yeah, Your Honor? Yes, thank you. I'm going to move to, for the moment, we'll come back to the other topic.
So good call right here. Gets another sidebar. I'm sure there was instructions on how to get this in, but he's like, nope, we're going on. We're moving on down the road. All right. So then we get into huge arguments about the freaking arm.
On various documents, you're a biomechanical engineer, but I've also heard you make reference to biomedical. Can you just tell me what you consider yourself, sir? Is it is biomechanical engineer something he refers to the page of his report?
Do you have a paper?
Engineer, I have no opinion on any aspect of, I think you're referring to Mr. O'Keefe's medical treatment or medical diagnoses.
So we get into the argument about him not doing force calculations on the arm. Yeah.
The Newton's second law equation, correct?
Correct.
So now we have an answer for F, 7,200 pounds. Now,
Yeah.
we go on to note that the applicable scientific literature states that a fracture to the occipital bone, and just to review, the
So he says, what's funny is Alessi says occipital bone quite a few times in here. Kind of I think he's kind of making fun of him a little bit.
So now we have an answer for F, 7,200
So instead of the occiput boner,
pounds. Now you then go on to note that the applicable scientific literature states that a fracture to the occipital bone, and just to review, the occipital bone is the back of the head right here, right?
Correct.
So you then, as I understand it, you go to the scientific literature, and you concluded that a fracture to the occipital bone can occur with an average force of 1,634 pounds from a fall distance of 40 inches, correct? I'm sorry.
How many inches?
40. That's in your report?
Well, you mixed two things together. There was stuff that reported force data. You had those numbers correct. A range of between 1,150 and 2,150.
yeah, I know. I saw some of that. I saw some of that commentary that, oh, you know, yeah, I did. But he just, the problem was he wouldn't answer damn questions.
1,634 pounds. And then it says, and a drop distance as low as 40 inches.
Right. And is the number 634 pounds a proper number for an average force?
Did you say 1,634 pounds?
1,634.
Yes.
Okay. So what I want to do is see if this is correct. So if you can get a fracture of the occipital bone in an average force of 634 pounds.
No. 1,634.
I thought that's what I said. If I did, I missed.
Oh, I'm sorry. I just heard 634.
No, 1,634.
My apologies.
And you
You're welcome.
compare that to the 7,200 pounds of force that you calculated. Surely you're going to have a fracture of the occipital bones through that calculation in that comparison, correct?
Correct. Falling on a hard surface can definitely fracture your skull.
So
All right. So this goes on for a while, and I don't know. I mean,
Right, that's the falling back.
We started getting more or higher ankle and lower leg injuries. So the change in the technology. But for backing, that may not be the case because you have different geometry on the vehicles, and you have.
We'll call it a spoiler. You visited
Called
the
it
scene
being
of 34
yesterday.
Fairview, correct?
I did.
You stated that you like to visit the scene while you're working as an accident reconstructionist so you can get a better understanding of the data?
I don't know if I've used the word like, but we want to go to the scene to see the scene.
Crazy.
When you visited 34 Fairview, did you go into the garage at 34 Fairview?
No, I actually didn't set foot on the property.
No. Oh, why would you ask such a question?
You didn't set foot on the property?
No, I stayed in the street. It's my understanding there were new owners.
So the jury has no idea about who owns the house now. So
Did you consider the scene limited to the road?
So the access I had was to the road. The laser scanners and the photographs will extend further, but I didn't have access to the interior of the house.
Oh, so you didn't access the entire scene, correct?
In my opinion, I did access the entire scene. I didn't physically step 7 feet onto the grass to the point of rest, but I stood and photographed where that was. I didn't want to trust it.
this is the crazy part too. He keeps saying these things that 7 foot onto the grass was where he came to rest, but there's nothing that ever lays that down.
The entire scene, correct? Located.
I know it was 7 feet in from the grass. I've seen cruiser cameras showing people around the body. It stood and photographed the scene. I didn't physically step 7 feet onto the grass to the point of rest, but I stood and photographed where that was. I didn't want to trespass.
Where did you understand the body of Mr. O'Keefe was located?
I know it was 7 feet in from the grass. I've seen cruiser cameras showing
That's
people around the
never
body.
been
It's
established.
Slightly north, and I guess, or excuse me, slightly south and a little bit west of the flagpole.
But you didn't access that part of the scene that you just described, correct?
I absolutely did. I took photographs of it. I didn't trespass and stand at that exact location, but I stood right there. We scanned the whole thing. The scanner uses a laser beam that goes out, 150, 200, 300 feet. So we scanned all that stuff.
Did your scan topography?
Yes.
Then you know.
Then we talk about the berm and
of Mr.
Is whether he was completely in the road or up on the berm. But for example, where the tire spins on the Lexus, that could be where she's driving up on the curb. And so then that tire will be at the height of the curb.
that could be. It might be. He might have had his head down. I mean,
standing on the higher part, and the right rear tire of the Lexus goes up there and spins, then that would be at the same height. We don't know the exact point of impact. So I don't know whether he was on the road or in the street. Excuse me, on the street or on the side of the road.
Exactly, but when you did your depiction on your slide, and
You assumed he's on the road.
Absolutely. Yep.
Where was it? Was it you in that slide?
It was.
Dressed in the clothes?
On the ground.
Not on the road, correct?
Correct.
Okay, so you chose a measurement, which was the ground, to the top for the spoiler, and you took a measurement. And you said that approximates the height of Mr. O'Keefe, correct?
Of the laceration on Mr. O'Keefe.
all right. Now we get to probably, let's see, where are we at on here? 307. Okay, so that comes up. That comes later. I thought that was here, but nope. That comes
Exactly.
all right.
You were doing was you were trying to determine and present testimony on whether or not that laceration could be caused by the spoiler, and to do so you had to take measurements, correct?
Correct.
So you chose to place Mr. O'Keefe in your simulation on the ground. You didn't choose to put him on a berm that would be 4 inches higher, did you?
Nor did I put the Lexus 4 inches higher. I didn't buy either one of those.
So yeah, back. All right. So then we have lunch. Then we have more argument about injuries.
Correct. We didn't have enough information to do it.
Do you present a force calculation for Mr. O'Keefe's right arm, do you?
Correct. We didn't have enough information to do it.
So if you are going to say that his arm broke the taillight, you have to know how much force it needs to break the taillight, and plus how much force it takes to break your arm, because there were no breaks. Now he does say, the arm wasn't x-rayed, blah, blah, blah. But they said, there was no indication that his arm was broken.
We're going to get to that.
We're going to get to that.
Given that you stated that, quote, determining the effects of physical forces on the human anatomy, end quote, is the job of a biomechanical engineer, you must have conducted several force calculations related to accidents involving humans in your career, correct?
Hundreds.
Now,
why didn't you do it here?
Force calculation in your materials, as you've stated on direct, with regard to the arm and I'll include in the right arm going from the shoulder all the way to the tip of the hand. Okay, so that's my definition of a right arm. You didn't present any force calculation on that part of the body of Mr. O'Keefe, did you?
Correct.
Traveling at 20.
Right,
So assume that the Lexus SUV was traveling at 20 miles an hour. All right.
So now we'll get into a whole bunch of equivocation.
20 miles an hour. And the third variable I'd like to give you is to assume an impact window of 10 milliseconds.
Okay.
All right. So this was, I don't know. I don't know how much the jury really hit on this.
Over 300 G's on the arm?
He's trying to say that
on the mass of the hand.
What is the range of force that you would need to break a bone in the hand? Do you know from the literature? If you don't, that's okay.
I could probably figure it out.
How long would it take
Figure
you
it
to
out
figure it out? Do you
from
know
the
from the
literature?
literature what that number is?
Not off the top of my head, no.
Is 300 to 400 pounds of force sound right from the literature that it would take to break a bone in the hand?
For a distributed load, such as the taillight, no.
No, not a distributed load. A load from a motor vehicle going backwards.
Right, that's a distributed load.
Right. So you're saying 300 to 400 pounds of force would not be enough to break any bone?
now they argue about distributed load versus.
I sit on the corner of my bed. But what happened?
This is so stupid. So now he's going to argue that there's no way to break a bone in your hand if it hits the flat surface. Like if a car would run into your hand or your arm, and it might not break because the load from your arm is distributed across a wide area. This just
It has a very fine point and jam it through my hand. I can jam it right in general. I can't answer your question. It depends on the load.
Force to break a bone in the hand. Do you disagree with that?
Your question is too general. I can't answer your question. It depends on the loading. If I take my pencil, which has a very fine point, and jam it through my hand, I can jam it right through my hand because it's a very small point. But if I distribute the load and a broader load, such as hitting a taillight, it takes much more force because the load is distributed across it. It's like if I sit on the corner of my bed. I might sink in this far when I sit on the corner of my bed. But what happens when I spread my load out, when I lay on my bed like this? I don't sink in as far. Has my weight changed?
what happens when he spreads his load out. I don't want to know.
No, but
I don't want any part of that.
area. So for a given force, you get less sinking into the mattress. So if you hit a broad surface like a taillight or a wall like this, it takes much more force than if I were to take a singular small round object and jam it into the hand. That hurts.
This is setting up for ARCA. This is mainly setting up for ARCA. This guy is digging himself a hole. He's saying that no, it takes so much more force to break a bone. I think ARCA is probably going to come in with some experiments that they've done and show, nope, you're wrong.
This does not.
You have no idea what you're
My
talking
question
about.
is unclear. You access in any manner where you can get a break to the hand from 300 to 400 pounds of force.
Any part on the back of the Lexus?
Yes.
Probably.
Okay. So probably, your words, you can get what you just said, correct?
So you potentially, yeah. But from a taillight or a broad flat surface, no.
Not asking about a taillight. Any part of the back of an SUV, you agree that it is probable.
So back and forth, back and forth.
Not include the rear body panel. If you hit a very narrow
rear body panel
part of the car, like say the edge of the tailpipe, that creates much more of a narrow contact.
This comes up here, so we'll get tailpipe. He says he brings up tailpipe.
So force.
He brings up
So
tailpipe.
you have a very tiny area. You have very high contact pressures, and so but if you distribute the load over a larger area, the number on the bottom of that fraction is much bigger, so your contact pressure drops. So hitting the edge of the exhaust pipe is going to have a much higher likelihood of causing fracture than hitting flat against the taillight.
Oh yeah, this goes on and on and on and on and on.
300 to 400 pounds of force to break it. Is there any part, for example, the edge of the license plates, above the license plates, the L symbol that sticks out that would be concentrated? Anything
Still
you see
arguing
over
about
300 to
300.
pounds of force, contacting at any of those points cause a fracture of any of the bones of the hand.
So I don't know how to show this because in the middle photograph, right where the 2 is on the license plate.
Yes, of course, you could have a fracture of the hand on that gate.
Just to be clear, 2188 is the number I calculated for you. It's not, quote, my number.
I understand, but we did the calculation. Is there anywhere on the back of the vehicle where 2188 could cause a fracture of the hand?
So that was a forearm fracture tolerance I thought we were talking about, because we used a weight of the whole arm for that.
We did. And my question is there any
I'd have to look at whether, that would take it before breaking the plastic.
whatsoever in
Blah, 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 blah.
reviewed that there was a fracture of any bone in the right arm of Mr. O'Keefe?
Not that I saw. Again, it wasn't x-rayed.
Was there any indication in the medical
Equivocation. Well, I didn't see it, but it wasn't x-rayed.
bone anywhere in the body of Mr. O'Keefe?
Yes.
Other than the occipital bone or
Occipital, not the occiput.
the skull?
There's a couple bones in the skull that are fractured, but other than the skull, no.
Correct. So, are you aware?
Equivocation. Always got to be equivocation.
Of Massachusetts, Dr. Shorty Bello performed an autopsy on Mr. O'Keefe. Are you aware of that?
Yes.
And you're aware of it?
All right,
Should
so
have x-rayed that to determine whether there was a hairline fracture. Is that your testimony?
No, you're asking me about evidence and proof of absence of fracture. So I would look for an x-ray to see if that was the case. I haven't seen any evidence of an x-ray of the arms.
So it's your position that on every autopsy, there should be an x-ray of every bone. Do you understand whether the absence of any fractures other than the skull of Mr. O'Keefe was of significance to the medical examiner, Dr. Shorty Bello, in the conclusion she reached in the autopsy report that you read?
System.
Did you read the conclusions of Dr. Shorty Bello in the autopsy?
I believe so.
Are you aware of whether Dr. Shorty Bello has analyzed whether the injuries to Mr. O'Keefe are inconsistent or consistent with a motor vehicle impact? Are you aware of any analysis to that effect?
So I'm going to see you on this one.
Do I have that at side?
So sidebar. We gotta argue about that.
So generally, I want to show that the location, area, and span over which that headlight covers matches the location and area of the lacerations on his arm.
That's what I want to get to. So you discussed data that you say shows that that you say shows the Lexus SUV was traveling above 20 miles per hour during the period that you allege the SUV made contact with Mr. O'Keefe. Is that correct?
No. Where'd you get that from?
Hold on. Okay. The answer is no. So did you do a test involving 20 miles per hour?
I did some other backing tests. Yeah. I was looking at how the rear pedestrian system and what warnings you got from the rear pre-collision system, the PCS system.
Let me ask you this. Would you agree
As part of your paint
that
test?
you did a blue paint test with the vehicle going at 2 miles per hour? Did you? Of course. Okay. You did.
So
Is where it started.
Right. And you don't have that information.
The problem is also where it landed.
Those are the same thing.
Right. You don't have where under your view, the body of Mr. O'Keefe landed precisely. You don't have that information, do you?
What do you mean by precisely? We know it's 7 feet off the road. We know it's near the flagpole.
Did you
We
have
don't
a
know where it
measurement?
started. The problem isn't where it landed. The problem is where it started.
Right. And you don't have that information.
The problem is also where it landed.
he still comes back to that whole this fucking guy.
Now we're back to John being.
Then it backs up, passes where it initially started, and goes 53 feet further back.
That's what I want to get to. How many
What?
feet
When?
did you?
Oh, then what's that?
7 minutes.
Oh, Alexa. Okay.
And did you just say now that it went 87 feet in reverse?
Correct.
Okay.
From its furthest point forward.
Well, that's what I want to get to because I want to have this point clear. How many feet do you believe the Lexus went in reverse?
This is never clear. I have no idea how far this thing
went forward
went.
and then came backwards. How many feet do you believe that vehicle went in reverse?
Your question doesn't make any sense because when it went forward, then it went in reverse.
Your answer.
The question is, how long did it go how far in reverse did it go in that triggering event? How far in reverse did it go? Not did it pull forward and then go backwards? How far do you think it went in reverse?
The answer doesn't make any sense. He asked you about the reverse part.
So it went a total of 80. It went 34 feet forward. Then it came back 80 or another 53 feet past where it went.
Exactly. So you
feet past where it
testified that
started?
the 1162-2 trigger event represents a backwards maneuver, correct?
So again, that was clear. It initially pulls forward and then backs up.
I would like you to define, so it's clear to the jury, do you consider the event of 1162-2 just backward movement, or do you consider the trigger to be forward movement and adding to it backward movement? Which one?
So can we pull the slide up?
Sure.
All right.
depressed
So
greater than 30%, and it be caused by wheel slippage. That can occur, correct?
The wheel slippage does not cause the accelerator pedal.
I'm not saying a cause and effect. I'm just saying a correlation. Do you understand what I mean by a correlation?
If I may try and straighten this out. So applying heavy acceleration can cause the wheels to spin. Is that what you're asking me?
Yes.
Yes.
Okay, that's all I.
oh God.
Wanted to get at.
Okay, so
in your review of the materials that are related to January 29, 2022, did you become aware of whether there were, and you said you extensively reviewed documents, did you become aware whether there were people at 34 Fairview?
Yes.
And
all right, so then this just keeps going. So they're going to get into the people at 34 Fairview. Then there's a whole sidebar commentary about that. Then he comes back and says, you know, basically Jim McCabe testified that the Jeep was there. He's trying to get him to say if
at 34 Fairview between roughly 12 and 1 a.m. Do you have an understanding of that, sir? Approximately.
I believe I do.
And what is that number?
Did you want them people that were there for that entire window of time, or just
yes, 12 to 1?
Answer the question. So, Mr. Leslie, just move to the last question.
Right, sure. So, sir, did you assume that there were cars parked out front of 34 Fairview at that 12 to 1 o'clock window? Did you assume any cars parked out front?
The entire time?
No, I'm just talking 12 to, any time between 12 and 1. Did you make any assumptions whether there were cars parked out front?
equivocation, gotta equivocate, gotta just, I can't answer the question.
There was a vehicle behind it.
I'm sorry, light vehicle on the front, out the front of 34 Fairview. 34 Fairview, that there would be a collision of the Lexus SUV with a vehicle out front.
No, the vehicle had left prior to the end, or prior to event 1162-2.
What information do you have with regard to how many vehicles are in front of 34 Fairview at between 12 and 1?
So I have Miss Reed's interview statements. I have statements of a number of witnesses. I don't know if I'm allowed to say the names.
I'm just going to say, let's not just number of vehicles.
Okay, so I have a number of witness statements
Answering the damn question.
before the event.
One vehicle parked out front of 34 Fairview. Is there a likelihood?
So dumb.
It's 24 miles per hour.
Oh my God.
87 feet. Is there a likelihood that there would be a collision given the weather conditions as you knew them to be at that time?
Well, the weather I don't think necessarily plays into whether there would be a collision or not.
So the slippery road, the thought that it's snowing now has no bearing on whether a collision would happen or not.
But we know
Okay.
it backed up 87 feet. So again, it goes forward like.
The thing about the 87 feet too is that the tech stream events that they're talking about is a 10-second window. He is talking about the car pulled forward 30 feet, then it went backwards. It measures things 5 seconds before and 5 seconds after the event. The event that triggered this was pressing the pedal down more than 30 and going backwards. What he's saying and what he's said in the past is at the end of that text stream event, and this came up yesterday because he mistakenly said in one of his slides that the car stopped at one point when the text stream event ended. It didn't. It was traveling at 20 some miles an hour, supposedly backwards, when the event ended. So the car didn't just stop because the text stream event ended. It was still traveling backwards. So
The distance covered, correct?
Correct.
So, but you're saying the distance is 87 feet, correct?
87 feet backwards, yes.
So backwards, 24 miles an hour. Have you ever driven a vehicle backwards 24 miles an hour, sir?
Yes, I think I've driven this Lexus backwards 24 miles an hour.
So if anybody's driven a vehicle back, have you ever driven any vehicle back 24 miles an hour at 1 o'clock, 12 o'clock in the morning?
Probably not since I got out of high school.
Have you ever done it when there's a storm that is beginning?
No.
Have you ever done it when there is less than clear visibility?
No and no.
all right. So we get to one of the most absurd moments of the entire freaking day. They're still arguing about this. They're arguing about if this vehicle's traveling backwards at 24 miles an hour, could it have gone back on the lawn? Because remember, it doesn't stop right at the end of the text stream of it. It's still traveling backwards. So the 87 feet is only the footage of the travel of the vehicle captured within the event. There is still an undetermined amount of travel of the vehicle. Now, you would think if this vehicle is going backwards, okay, if, and this is even stupider. If she is parked where they said you were, right across from the door, right? And it pulls out and it goes 30 feet. And then it travels back 30 feet and then another 50 feet. It's still rolling and it's still traveling and it keeps going. You would think that the brake would have to be applied pretty heavily if you're going to slow a car down going from 24 miles an hour backwards in the wet. But this guy will, so that should trigger a new text stream event, which it has on other key cycles, which I think they'll get into in their case in chief. But this time it doesn't trigger so she just lightly applied the brakes. And so that, yeah, there's so much wrong with this. But now we get into the possible versus probable. And this guy being a complete, this is like the jackass moment of the day.
Going 24 miles an hour at this location, 87 feet backwards.
37 feet going up on the curb.
Wet pavement at a minimum. And low lighting, you don't believe it's possible for the vehicle to, under your scenario, to have gone up on the lawn? That's not
So
possible.
your first question was reasonable, and I said no. Now you're asking possible. It, of course, is possible. Whether it's reasonable or not, I'd have to know the starting position. Right. If it's very close to the side, then it could be reasonable. If it's further towards the middle of the road because snow is building up on the side of the road, then it's probably not as reasonable. I would need more information to be able to determine whether it's reasonable or not. It's certainly possible. It's possible it could have shot off into space as an engineer.
Oh,
but
is
not
it?
probable.
Is it?
Oh, you
Tell
think
us
it's
more about
possible
that.
that it could have been shot off into space, sir?
As an engineer, it's a possibility.
It's a possibility that
Absolutely.
this Lexus could have been shot off into space.
Yeah, highly, highly unlikely. But again, you're asking an engineer about possibilities and probabilities.
Let's get back to reality. So in terms
Just going to play that again without commentary.
could be reasonable. If it's further towards the middle of the road because snow is building up on the side of the road, then it's probably not as reasonable. I would need more information to be able to determine whether it's reasonable or not. It's certainly possible. It's possible it could have shot off into space as an engineer.
Oh,
but
is
not
it?
probable.
Is it?
Oh, you
Tell
think
us
it's
more about
possible
that.
that it could have been shot off into space, sir?
As an engineer, it's a possibility.
It's a possibility that
Absolutely.
this Lexus could have been shot off into space.
Yeah, highly, highly unlikely. But again, you're asking an engineer about possibilities and probabilities.
Let's get back to reality.
Why does he bring engineer into this? He says that the vehicle could possibly get shot out into space. And then he brings in being an engineer, everything's possible. That, I got to see what, we got to check Emily on this. We just got to, let's find it. I know she's got it. We got to see this.
Highly, highly unlikely. But off into space. We need more information. Whether it's reasonable or not, I'd have to know the starting position. Right. If it's very close to the side, then it could be reasonable. If it's further towards the middle of the road because snow is building up on the side of the road, then it's probably not as reasonable. I would need more information to be able to determine whether it's reasonable or not. It's certainly possible. It's possible it could have shot off into space as an engineer, but not probable.
Oh, you think it's possible that it could have been shot off into space, sir?
As an engineer, it's a possibility.
It's a possibility.
Look at the guy's eyes. Look at these crazy freaking eyes right here. He's like, this shows this. He let his real personality slip right there. He has been holding in his, we talked a few times about some of the little pissing on the tree, marking his territory. Just, I'm the smartest person in the room attitude, this ego that he has, right? This is where he lets his real personality slip out into the world.
I'd have to know the start.
Watch these eyes. It's Brennan's got it too. Brennan has got it too. The voice raises, the assertion raises, and watch the eyes.
If it's very close to the side, then it could be reasonable. If it's further towards the middle of the road because snow is building up on the side of the road, then it's probably not as reasonable. I would need more information to be able to determine whether it's reasonable or not. It's certainly possible. It's possible it could have shot off into space as an engineer, but not probable.
Oh, you think it's possible that it could have been shot off into space, sir?
As an engineer, it's a possibility.
It's a possibility that
Absolutely.
this Lexus could have been shot off into space.
Highly, highly unlikely. But
Right.
again, you're asking an engineer about possibilities and probabilities.
Let's get back to reality. So,
I think that's the first time I've heard a lessee make a snarky comment to a witness during testimony with the "let's get back to reality."
What in the hell are we doing?
Sir. No. Just no. He's very entertained by himself. You're a paid expert.
Yes, he is. He's very, very entertained
Does
by
Alexis have
himself.
like magical powers or rocket boosters that we are not aware of? I can't even. I can't.
Now, a Tesla Roadster can be shot into space on a spaceship many years ago, which is still circulating the Earth. Not a Lexus in Massachusetts.
I can't even. I could just go
I mean-
into space.
On the lawn, you can't rule out that under your scenario, the vehicle would have gone up on the lawn. You can't rule that out, can you, sir?
I cannot. No, it could've.
Okay. Now let's go to the next topic.
I mean, just
In terms of the Lexus
all right. So then we get into the
as it drives past him, is that correct?
the
Would I
arm.
characterize it that way? What's
Would have been caused by the vehicle scratching Mr. O'Keefe's.
So the biggest part about this is we notice all of these are in the same orientation, right? Pretty much in the same orientation. If your arm is hit, if your arm is like this and you get hit in your arm, so you're bent, right? This portion of your arm gets hit, this portion of your arm gets hit. If you're sliding off and the scratches are going to be different orientations if this is the same exact event, right? Because they're saying this the tail light caused these injuries. If you're saying that this happened in one event, the injuries down here would be in a different orientation than the injuries up here. That is basically all he's getting
I
to.
don't know. I characterize it that way. What happens is, the 6,000-pound vehicle is coming, and he's standing on a, icy, snowy roadway area, and it's going to contact him and move his whole body and induce rotation.
Yeah, exactly. Now it matters that it's icy, snowy.
It's going to contact him.
Now the weather matters.
And under your theory, induce rotation. So, wouldn't such a movement of the car relative to his right arm result in horizontal injuries to Mr. O'Keefe's arm, as can be seen on his bicep above the elbow?
So could we pull up one of my slides to address this issue?
Sure,
I'd like to answer.
Like then he starts going through his stuff again. What the hell?
Your question with a slide that I have.
He's just digging through his report now. This is completely crazy.
You don't get to do that.
Addresses this exact
Stop reading your
point.
notes.
I'd like to stay with this slide, Dr. Welcher, and see if you can answer my question off this slide. So I'll repeat it.
Oh yeah. Oh, exactly.
That the injuries up at the upper
Why is he
part-
reading his notes?
I'd like to answer your question with a slide
Well,
that I have
you don't get to
that
do that.
addresses this exact
Stop reading your
point.
notes.
I'd like to stay with this slide, Dr. Welcher, and see if you can answer my question off this slide. So I'll repeat it.
Sure.
I mean, not my
Do
questions.
you
literally,
agree that the injuries up at the upper part, where you're familiar with the bicep brachialis?
I am.
And aren't those two up at the top, right over the bicep brachialis?
They're actually about midway between the biceps and the triceps.
Right. So you know which two I'm talking about, the two up there. Can you just use your laser pointer just so we're talking about the same two? Do you have one?
I'll give it a try, but the upper ones.
I know
It's
it's not your fault, but
Only-
on the
sometimes it
image,
doesn't.
the upper left. I mean, technically, the ones right to the right of that are also on the biceps and triceps.
Right, but I'm
biceps goes all the way to the elbow, so to the triceps.
Right. So I'm talking about the two that are the farthest up.
With your arm like this and the tail light coming across like this, which is what I showed in my slides.
My questions are
trying to keep this moving. I just asked if those are
The
in a
squirrels in my yard
horizontal
are,
orientation.
Yeah,
Yes
more
or
or
no?
less. They're angled down slightly, but more or less horizontal.
Okay.
Like literally.
It's perfectly horizontal. When you're standing like this, and this is the tail light, the laceration, when it comes across here and pushes my body, it's going to make a horizontal laceration because the 6,000-pound vehicle is going to push me out of the way. As this pushes me out of the way, it's going to drag and create a horizontal laceration across my arm. This is exactly what you'd expect.
So let's talk about the forearm, sir. We may have miscommunicated. I'm talking about the lacerations on Mr. O'Keefe's forearm now.
So we're switching from the arm to the forearm.
Correct. Wouldn't those be oriented in a vertical direction?
No. Again, you have the vehicle. If this is me and this is pushing across like this, and with your arm bent like this, it's going to cause laceration. As it pushes my arm away, it pushes like that.
Okay, I got it.
My slide shows this quite clearly.
So you disagree. You do not agree that the injuries to Mr.
This is another setup right here.
O'Keefe's forearm, under your theory, would be oriented in a vertical. You disagree with that. It's just want to get that on the record.
I disagree with
Okay. Now, also,
All right. Ugh. Now we'll get into
if you give an
the other just absurd statement from this guy today. Just the pomposity, the just I am the smartest guy. Yeah. This is just
if you given a horizontal movement of the car, do you agree that it's more likely than not that vertical lacerations would be an inconsistent jury pattern?
I'm trying to help you, but you got to give me more. So, like, is it a clipping contact?
I'm trying to help you. I'm here to help you, Mr. Defense Attorney.
You're on cross. It's so patronizing. I'm trying to help you.
Survey says.
Just the audacity. Oh my God.
Is it not a clip?
He's asking you a question. If you can't answer it yes or no, then you say, I can't answer it yes or no. He said, you keep inserting this shit. And he says, I'm trying to help you. No, you're not. You're trying to help you. Obviously.
More likely than not that
Oh my
vertical
God.
lacerations would be an inconsistent jury pattern.
I'm trying to help you, but you got to give me more. So, like, is it a clipping contact or is it not a clipping contact? Is it a direct in the center of the car impact?
Okay, are there only two variables you need to answer the question?
But this is a good start.
All right, so let me do it this way. You can't.
All right, so the on and on and on and on. They go. We do get into the
No, because I was able to reject them. I didn't come in here to tell these light fragments near his body, the lacerations, his height, the height of the taillight in a Lexus. So it was an iterative process.
Did you mention any of these supposed hypotheses of your direct testimony?
They basically
I was able
asked
to
him.
reject them. I didn't anywhere on the back of it. Then will it?
He's very annoying. But there's times he's absolutely right. I would be annoyed.
Oh, I think I just
I'd be
included
annoyed.
photographs of that damage.
I would be so annoyed. He's very annoying. But there's times he's absolutely right.
Sure. In the beginning of this, I started about, hey, it's all over. It could be anywhere on the back of it. Then whittled it down based upon the evidence, started eliminating various hypotheses based upon the evidence. And
You assumed that the
started
taillight broke
eliminating
because
stuff.
of a collision with John O'Keefe. That's the first assumption you made.
Yep, exactly.
So everything from there starts with the assumption that there was a collision. Did you ever assume that there wasn't?
Right.
This
Exactly.
conclusion, eliminating hypotheses based upon the taillight fragments near his body, the lacerations, his height, the height of the taillight in a Lexus. So it was an iterative process.
Oh.
Did you mention any of these supposed hypotheses of your direct testimony?
No, because I was able to reject them. I didn't come in here to tell these people what didn't happen. I came in here to tell them what I believe happened.
Would you agree, sir, that the
These jury people. I will say, as far as all the experts go, this expert has looked at the jury the least of, I think, any expert.
identify various hypotheses?
No, he's like, I'm here to tell them what
Show the
happened.
data that supports it, but you show your math as to why you're rejecting hypotheses. As you said, you rejected them. I'm asking for proof that you considered other hypotheses. Do you have anything in writing, any notes at all, any videos, any tests that you did, documentation of other hypotheses other than picking this one?
Basically, he's asking him, did you consider that this was not a collision? Do you have any proof anything, any notes, anything that you have done as a scientist, as a accident reconstructionist. Let's assume that there was some other way that the person fell and hit their head, that there was some other way that those scars, those cuts got on his arm. Did you form any hypothesis that this was not a collision with a car? That's what Alessi's trying to ask him. And do you have anything to back up that you considered anything else? Or did you just consider trying to make the evidence fit what you thought happened, what the Commonwealth thought happened? Show us where you looked at anything else, because ARCA did that. ARCA was given all that, and they said, well, let's look at this objectively. Let's not assume that there was a collision.
So I did a bunch of tests with the Lexus. I did backing tests. I looked at how
Where are those?
the rear system worked.
Where's
to see if
that?
it would autonomously brake. I confirmed it did not, so I eliminated that.
He was going to get that answer in here at some point, wasn't he? Nobody had asked him. He really wanted to talk about it. I'm glad he did. Really long time.
System worked to see if it would autonomously brake. I confirmed it did not, so I eliminated that as a hypothesis.
How?
I tested the steering. I tested the transmission, what 1, 2 represented. So I did a whole bunch of tests on the vehicle.
What test did you
Everything associated with a collision.
do for the autonomous braking? Did you put a crash test dummy behind the car and go flying back into it?
My question is, did you ever take the vehicle and position yourself or anybody else in various locations to determine whether or not your hypotheses could be properly rejected? Do you have any documentation that you did that?
I mean, I did do 1 static and 2 dynamic tests in very similar positions, though. So I did a total of 3 tests relative to the arm.
Where's the documentation for that, sir?
It's in the file. I gave it to you. The slides are some of it.
All right, so Mr. Alessi, I think if we're going to...
I am, and I'm going to move on, Your Honor.
So...
Okay, Mr. Alessi, hold on. We're going to do that for you.
Can I ask, I just have one other area, Your Honor. I can do it in short order if I could, please.
We're doing a voir dire?
Go ahead, finish your answer.
So slides 109, 110.
We're going to do another voir dire?
Mr. Alessi, it's your voir dire.
All right. So, final thing today, they're basically, now they want to get in he wants to go back and he wants to get in the key cycle thing. So he has to show that Trooper Paul's report was used, that he went through Trooper Paul's report and he used some of it. So he finds this picture.
In the car's report of Trooper Paul.
I believe it was.
So you took that drone image from the car's report of Trooper Paul, correct?
Correct.
That image, and you put it in your...
So he also needs to get in. He also needs to get in the
I do a folder that contains a bunch of things.
So basically, he needs to get in that he took stuff from Trooper Paul's report. Therefore, Trooper Paul's report can come in and he can use it. This guy is saying the drone picture that he used is from a folder that said report, cars report or whatever.
25
from Trooper Paul's
PowerPoint
file.
that you created. And I'd like to go to slides 25, 26, and 27.
I just want to know if he was told not to use anything.
Have you
from Trooper
discussed
Paul's
with
report,
anybody?
And then he went and used the image from Trooper Paul's file. And what he's saying is, but it's not in the report.
Yeah, it's not in the report. It was just in the file. I was given all these files.
Curious if that's why he's so defensive.
So,
Where did you get you see the larger chart to the left there in the, looks like mostly a rectangle. Do you see that, sir?
What slide are you on? What slide is that?
yeah, anyway, so basically this is about trying to get it in.
Go to slides 22 and 23.
Okay.
Who would you conclude it is in those photos?
It appeared to be Trooper Paul from other. These 3.
Then he does use this. He does use this photo from Trooper Paul's report.
I don't know who that is.
Okay, and if you don't limit it to those 3, who would you conclude it is in those photos?
It appeared to be Trooper Paul from other photos.
Okay, so you can tell from other photos that this is Trooper Paul in these photos, correct?
Now, I'm sure Bev is not going to allow this. She is going to figure out a way to keep this out. She's going to say, well, the pictures were even though they were in a folder labeled Cars Report Trooper Paul, Well, they were just pictures, and he can use them. He's free to use them in his
I don't know that
report.
someone else switched out. I have no reason to believe this isn't anybody but Trooper Paul.
Would you have any understanding that there's any other trooper that would be doing this type of analysis other than Trooper Paul?
Someone else took the photographs?
No, I'm talking inside the vehicle.
I'm sorry?
Inside the vehicle.
Someone
doing
else would
what's
have to be in the
depicted
photo to
here.
take the picture, to be fair.
Someone's inside the vehicle taking the photograph.
What's your best conclusion as to who that is?
Trooper Paul.
Thank you.
Take your word for it on page
All right.
So, but it is from Dr. Scorty Bellows' autopsy report, correct?
Then
now, if you could
we've
go
got
to
get in. So there's some other reason they need to get in that he used the autopsy report.
Okay.
Then we have the most. I'm not going to play this because I just cannot stand this guy, but Brennan does not know how to just control himself. He has to get angry and sound angry.
Of the street of Fairview Road. Did you know that didn't come from Trooper Paul? It came from the CERT report, and Trooper Paul then took it from the CERT report and put it in separately in his presentation?
There are people saying online that this is not true. That he's saying that drone photo came from the CERT people, and Trooper Paul took it from the CERT people. But Trooper Paul testified, I do believe, in the first trial that he did use a drone. So this might be a lie, but it doesn't matter. Brennan could just get up there and lie, obfuscate, say whatever he wants, and there's no penalty on it ever.
I had no idea. I just was given it as a folder.
And the photo you
Well,
were
if it
using.
comes up tomorrow, so hopefully they're looking at this, and Alessi's going to come back tomorrow and say, Brennan, you said that picture came from the CERT report, but it did not. It came from Trooper Paul. So, and then they'll just blow it over and not let it get in anyway. So, this guy drives me crazy. He is such a slime.
For your conclusions or any of your decisions or analysis in this case?
I did not use his report at all.
It was simply limited to the use of the photo to show a different demonstrative issue.
Correct.
And then when you saw diagram 1, again, that was different than what was used in Trooper Paul's report because it had information, looked at the car, and did everything individually, separately, and uniquely.
Yeah.
However, with Dr. Scordavello's conclusions regarding cause of death, whether it was accident, undetermined, or homicide. No.
Honor. You put in your slide presentation information from the autopsy report of Dr. Scorty Bello for a reason, correct, sir? And that reason is because you considered the autopsy report as part of your analysis, correct?
So I considered portions, which are the portions I included here.
Right, so you considered it.
The autopsy report.
So I considered the autopsy report, but only portions of it, right? So yeah, you can't really, fuck.
And part of
This
those
guy
considerations
just-
were the final
I
diagnosis.
mean-
Can we put that back up, Mr. Woke?
Right, where the findings.
But you recall the slide that you had your analysis, else it wouldn't be in there, correct?
So the final diagnosis is in there. There's a line, then it says cause of death, and then manner of death. The things I highlighted are the things I thought were important. So the highlighting on slide 130. So the final diagnosis again does not.
I used the report, but only a portion of it.
Things that I was
So
looking at are the under or highlighted, which is why I highlighted them.
Exactly. So the
Oh,
ones that you
God.
highlighted, you considered are from the autopsy report. That's why you're highlighting them, right, sir? You considered them.
Correct.
Thank you. No questions, Your Honor. I
All
appreciate
right.
that.
So I'm not going to let you argue now. I'll hear you very briefly tomorrow before we stop. Mr. Leslie, how much longer are you going to be?
all right, so here we go. Last thing today, and how much longer are you going to be? Because poor Mr. Welcher just can't stay. We're going to have a half day tomorrow because of a juror's got an appointment. But
On your ruling, Your Honor.
so listen to the sigh. Oh my God.
It depends on your ruling.
And look at her. What was that?
It depends on your ruling.
I'm about halfway through, Your Honor.
I'm about halfway through.
I think it will take up today. That's my best estimate.
So he did. He's
Look for it tomorrow. If we can get through things quicker, I would like to do that. But given today, that's my best estimate.
So we're half a day tomorrow.
Oh, that's right.
So she wants to try and push it.
We can, so that Dr. Welcher doesn't have to come back or stay here another day.
He can stay as long as it takes. That justice doesn't have a freaking time clock. There's no stopwatch on this trial. There's no stopwatch on how long you can cross-examine someone. You could cross-examine someone as long as it takes. So,
Oh, Dr. Welcher's getting played plenty, Your Honor. I wouldn't worry about that. I wouldn't. You told.
So let's just see what we can do, and we will do the same thing for your experts as well.
No, I understand, Your Honor, and I respect everything that Your Honor is saying. I must say, Your Honor, to state the obvious, this is the key aspect of the case.
Yes.
And we've got to be able to proceed through with the questions.
They need the time they need.
And I'm not asking you to curb it. I'm just hoping that we can do it. So I will ask you.
Britain is going to have a completely gregarious re-examination, right? Brennan is going to go for a while on his redirect. So this guy's going to be here on Friday. There's no getting around it. A half day tomorrow. This guy is going to keep arguing with Alessi. He's going to keep fighting everything he can, every way he can, right? So it's going to be another knockdown drag out. And Brennan is going to need time to get into a whole bunch of stuff to have him restate a whole bunch of his opinions. They're going to go through a whole bunch more slides. This guy's going to be here Friday. And this guy might be here most of Friday. I could see him being here most of Friday too. Maybe if they get through the half day tomorrow, maybe another half day on Friday. But there's no way they're getting through this. There is no way.
Tomorrow at a certain time.
Aren't you holding court on Friday? It's Wednesday, right? Like, I haven't hallucinated. It's Wednesday.
Yeah,
you have a half
exactly.
day on. You have a half day on Thursday. Why can't he just finish his testimony Friday?
Why?
Maybe instruct the witness to answer directly.
Thank you, Dr.
Yeah.
Welch.
Maybe.
Yeah. Instruct the witness to say, answer questions like yes, and not just when you give him, did you go through the VCH data? And I went through this data too. Didn't answer yes, I did, and then put his equivocation in. Every question has to be answered with an equivocation. Every single one. Oh my goodness. What a couple of days here. Are we going to see some sanity next week when we get to the defense's case? Are we going to see a return to sanity? Because right now, there is no sanity in this thing. There is no sanity going on right now. It is this whole case, man. This whole case is just every single day. It's something new. People lying to the FBI, people lying to the grand jury, people making stuff up. And, man, we had the absurdity of Man Shannon, and then we get the absurdity of Mr. I'm right on everything every time. Don't argue with me. Oh my God. Oh. All right. Half day tomorrow. I have a dentist appointment, and they're gonna knock me loopy. So I might be on a little later tomorrow, but I'm gonna try and shoot for, it's at noon, so I should be okay by 6:30 my time. We'll see. If not, tomorrow might be the stream to tune into, because God only knows what I'm going to say. But anyway, all right, I am going to get out of here, go get some dinner, maybe watch an episode of Game of Thrones, because I've never watched it, and now I'm watching it. And I will, on the outro here, hit you with a introduction to one of the characters for the show that I have created and filmed, at least the first couple of episodes. It's called Mistakes Were Made, making fun of the government and all the misinformation BS. So we got a little short here. That was go back the very beginning of the show. I showed the trailer for the show, kind of explains the whole setup. And then I got a couple little shorts here on the outro to show a couple of the agents, a couple of the government agents that we have in our show. So I think this is Agent Walker. He's the old grumpy dude. So I say old, not really. He's not really that old, but all right. Thank you. Thanks for hanging out with me. I will be back tomorrow. We'll go through tomorrow's craziness and we'll go from there. Oh my gosh. I don't know if it can get any crazier. We're going to send Lexuses into space. All right. Good night.
Introducing Agent Charles Walker from the Federal Enforcement Division, or Fed.
Misinformation is getting to be a very serious problem. It really interferes with what we are trying to do.
And what are you trying to do?
Excellent question. I'm afraid that's classified. You don't have the clearance.
Agent Walker is always a team player and appreciates the efforts of his colleagues.
You know those bum idiots. This is all them. We had a solid case.
Agent Walker is a master interrogator and would never take things out of context to influence an interview.
My cousin Mindy is the bomb. I'm just seeing a lot of incendiary and violent language here. Somebody could see a call to action in these words.
A call to action for what?
Well, you tell us. They're your words. You wrote them.
Agent Walker, a calm, patient presence in the fight against misinformation.
These people can't even do stuff that's actually good enough for government work.